that was available to be raised in review of the first stage order, and you didn't raise it, that it is not proper, that the commission could properly decline to reconsider it, and that we should properly uphold the commission's decision not to reconsider it? Or do you think even if that was an issue that was properly available for you on review, that the commission was required to reconsider it, and we should kind of address now the correctness of that issue?
I believe that the court was required to reconsider at the second stage, and I believe that because the DCMR is clear that at each stage of this process, that the second stage has to comply with the intent and purposes of the first stage. So I think this is
Well,
what
at the
Judge
first
Easterly was
stage-
getting at.
At the first stage, the commission made a conclusion that seems unqualified. This is in paragraph 9 on page 56. The commission concludes that it is not necessary for the applicant to include 4 and 5 bedroom units in the project. That doesn't go to the question of the number of 3-bedroom units, but it seems rather conclusive with regard to the 4 and 5 bedroom unit decision.
Yeah, yes, Your Honor, I believe that,
And,
I mean,
and the second stage PUD application now before us makes no change to that conclusion.
right, and our argument, our core argument that, this is that along with that finding in the order, that, hey, there wasn't 4 bedrooms and 5 bedrooms didn't have to be built, along with that order was also an order and a commitment to allow everyone to stay. And that these issues of if we need 5 bedrooms, if we need 4 bedrooms, moving down the line, would be revisited at the later stages of this process if it became clear that the need actually was there for large bedrooms. And I would argue that the second stage record shows substantially that there is
Can you
new
show me-
information
can you
available
show
that
me-
shows that,
Can you show me what in the first stage order you're relying on when you say that a conclusion like that was subject to revision by the commission?
you know what, Your Honor, I can't point to it offhand. I believe that my brief has citations from the transcript that show that both the large bedroom issue and the voucher issue were left open-ended at the first stage. And, yeah, okay, do you mind if I confer with my co-counsel for a second, Your Honor? Your Honor, I can't put my finger on the actual transcript portion right now that says that these issues could be open to stay. But I believe that just the idea that each of these orders has to comply with the intent and purposes and has to be reviewed, that commitment in the first stage is that everyone will be able to stay. It would be.
Could you show me again what language in the first order you rely on for the proposition that everyone, all the voucher holders, not just the Section 8 apartment unit dwellers, will not be displaced, will be able to stay?
What,
Because the vouchers might or might not, as the commission subsequently discussed, be large enough to meet the market rate costs of the units. So I'd like to know exactly what language.
the exact language that I'm depending on to assert that is in the first stage order, conclusions of law, paragraph 10, page 56. And again, it is that the commission also recognizes, in addition to the 373 project-based units being renewed, it says that the commission also indicating an additional obligation to people that are not living in the project-based units, recognizes that the applicant has committed to allow all households that reside at Brooklyn Manor at the commencement of the redevelopment in early 2018 with the right to return to the new Brentwood Village community.
Does the commission order that as a condition of the PUD?
No, but the commission, as a condition of the PUD, I think that the commission uses this rationale,
I mean, it seems to me there are two issues here. One is whether, what that means to say the right of return. And I confess, I had the impression that everyone understood at the first phase that that meant something different from there will be 373 Section 8 units here for each one of the 373 Section 8 apartment dwellers or apartment families now. And then the second question is, regardless of the expressions of hope that the applicant made and that you've cited there about keeping all the current residents or giving all the current residents the right to return, it's not clear to me that the commission has ordered that as a condition of the PUD. And that makes a difference because, in part because of the ambiguity of right to return. So this is what I'd like to nail down.
I understand. I think that it may be instructive to gauge how the zoning commission itself viewed the commitment in the first stage order if you look at what they did put in their conditions of approval in the second stage.
Can we just first go to the first stage order and focus directly on that? So
Sure.
in the part of the order that lists the public benefits and turns first to affordable housing, and that's, I guess, on page 59 and over onto 60 of the initial, the stage one order. There's a list of a set of things that for, for so long as the project exists, the applicant shall provide following affordable housing, and there's a whole list of public benefits relating to affordable housing. And I don't see on there anything that says what would have been a huge public benefit, which is not only are we absolutely guaranteeing, is the developer absolutely guaranteeing 393 affordable units relating to Section 8 housing, but they are guaranteeing affordable housing to every voucher holder who wants to return. They'll all have a subsidized right of return. That would be a huge public benefit, and it's kind of, would you agree that it's strange that if that's what people understood and the zoning commission intended the first order to mean, that it's not listed as a public benefit relating to affordable housing?
Your Honor, I believe that if we're talking about a community at Brooklyn Manor that at the time of the first stage order had 490 occupied units, and all 99.999% of those units were occupied either by people living on the property through the project-based units or people living on the property with a Section 8 voucher, to make a promise, an absolute commitment that everyone has the right to return without including voucher holders, when at the hearing, your representative specifically said this includes voucher holders.
I'm really not sure you're answering my question. I understand that there are other pieces of information you want to rely on, but what's your response to the following question, which is, if you're right about what was meant and understood, isn't it odd that that promise is not listed among the affordable housing public benefits? What you're interpreting as an absolute promise. Don't you agree that it's odd if that was understood to be and intended to be the promise, that it's not listed as a public benefit relating to affordable housing? Do you agree or disagree with it, that it is peculiar that it's not listed there?
I disagree. I think that the commitment to house everyone through and following the redevelopment was always understood by the parties at the first stage as involving voucher holders as well. Even if it doesn't specifically say a subsidized right to return.
Is there anything in the transcript of the first stage hearing that you can cite that supports this?
I would cite Mr. Muir's rebuttal testimony in the May 11th transcript. That testimony is the testimony that I've read from the findings of fact at the first stage order that the zoning commission summarized, that said voucher holders will have a right to return. It includes Section 8 voucher holders. That was the commitment made. It
When you say
was a
Section 8,
subsidized
I get a
commitment.
little, there's some uncertainty about Section 8. Do you mean DCHV?
I
voucher
mean,
holders or-
Section 8, housing choice voucher, yes, I'm sorry.
No, that's fine. I just wanted to
So
clarify.
that was the commitment made by Mr. Mears when he was saying an absolute right to return.
I'm sorry, absolute, is that his word or yours?
My word, I believe. So let me just
page
read
percent.
exactly what the court,
This is the May 11th transcript? May 11, what year?
2015.
And what's the page?
I'm not sure what the page is, but the actual, it's summarized in the findings of fact of the first stage. On page 52, paragraph 7,
I'm sorry, page 52, what?
paragraph 7,
I have page, in the first stage order?
in the first stage order. I'm sorry, Your Honor.
I have, the
Yeah,
paragraph numbers on that page.
Page 16, is that paragraph 47? Is that what you're directing us to?
If you'll forgive me,
Yeah,
Yes, I'm sorry.
Mr. Mears'
I
testimony.
apologize.
paragraphs
It's page
40
16.
47 through 49.
yes.
I mean, do you understand our discomfort with looking at factual findings, which frankly are not so much factual findings in this section, so much as kind of summaries of evidence taken or heard, right? And then, relying on that in lieu of the section of the order that is entitled decision, and then has the subsection, public benefits and lists benefits, as Judge McLeese stated, and those benefits are just 373 project-based units, and that's against the backdrop of the developer's argument saying, look, the contract would expire and we are choosing to renew it and to guarantee the 373 units. So from their perspective, and I understand that you don't share their perspective, they are giving you a net benefit of 373 guaranteed units.
And I would argue as a public benefit, that isn't a net benefit because there were 535 deeply affordable units there before this redevelopment process.
Right, and I come back to the fact that it was discussed and is discussed in the findings. Again, more akin to a summary of testimony heard and arguments made, that the Office of Planning as well as the association said, please replace those 535 units. And there was a recognition that there were some vacancies and that there were actually, 424 occupied units that would need to be replaced. And there's just, I don't see a commitment by the commission. I understand you're making arguments that Mid-City made promises, but at the end of the day, at the first stage order, I don't see where the commission said, okay, you have to guarantee affordable, returnable housing. And if our job is only to look at the commission's decision at stage 2 and say, because we don't get a do-over, right? We are just looking to see whether at stage 2, the commission's decision was arbitrary and capricious. I'm struggling to see how we can say that it was arbitrary and capricious if at stage 1, they only clearly said, you have to provide 373 project-based affordable units.
And Your Honor, I mean, in my response to that is what I've stated before, a commitment to that promise to allow everyone the right to return. If you agree that that was also a commitment made, an actionable commitment at the first stage because it was included as a public benefit of the project, my argument is that if that commitment does not include demographically the people who lived at the property at the time that commitment was made, which it wouldn't if it does not include voucher holders, and taking that in context with the representative of the developer who's wanting to redevelop this property and threaten displacement to people saying, don't worry, you don't have to go, everyone with a voucher will be able to stay. If it is not seen in that commitment that that includes voucher holders, then that is a completely illusory commitment. And that is why displacement happens the way it does in Washington DC, and
Could
why
you
we
clarify-
face the affordable housing crisis that we do.
Could you clarify something for me that I think would help me understand this a little bit better? How do these vouchers work? In other words, what is the amount of the voucher now, voucher holder now? Does the voucher holder get a voucher that pays 100% of the rent of the apartment?
The way
Or
the
does-
vou-
or is- Tell me how this works.
Yeah, the way the Section 8 Housing Choice Voucher Program works, which Ms. Elliott is a participant in, is that you pay 30% of your income, whatever that income is, as rent, and then the government pays the rest of that rent. The issue with this program is that it has rent ceilings. So I think as part of the record, in the first stage, I had submitted along
Well,
with.
wait a minute. Let's go slow here.
Sure.
So let's just take the current situation. You have a voucher holder now who is paying 30% of her income, however that's calculated. And the voucher pays the rest of the rent. Now, suppose that voucher holder says, gee, I just can't make that 30% payment. 30% is a lot, and I have other responsibilities. That voucher holder has, one could say, the opportunity and the right to remain, but only under certain conditions. Only under the conditions that the combination of the voucher and her own contribution equals the market rent. There's no obligation on the part of the landlord, if I understand correctly, to say, oh, well, since we've committed that you will be able to stay here in perpetuity, even though we'll make up the difference for you, or we'll lower the rent for you. Do you agree with that?
I agree with that, but I don't think
So
that that's.
how does that play in, then, to the issue you're raising? In the future, things could change. The vouchers might not be good enough. The economic condition of the, it's not like in other words, it's not like the Section 8 project-based units. The voucher holders in the future may simply be unable, for whatever reason, because the voucher isn't large enough, the voucher program has changed, the ceiling isn't high enough, whatever, things beyond the control of the applicant. How is the applicant even possibly to guarantee to these people that they will not be displaced?
I think very simply, Your Honor, the applicant can make a commitment that they would keep the residents that live at the property at the commencement of the redevelopment pursuant to a voucher. If at the end of this redevelopment, the Section 8 voucher program, if their rent ceilings meet the market rate, great, we don't have an issue. If they do not meet the market rate, that they would agree to keep their rents at that rent ceiling that the federal government prescribes pursuant to the commitment they made that no one be displaced.
Now, I realize they could do that. The thought that occurs to me is that that's such an amazing commitment, one could say, that one would think if that's the commitment they were making, everybody would have been talking about it, and it would have been identified rather specifically. And I'm looking for a place where a commitment with that specificity is being made and is being required by the zoning commission as a condition of the approval of this PUD. Do you see what I'm asking?
I see what you're asking, and I agree with you that there is nothing in place, as the judge said, that would say there is a guaranteed subsidized
But
right
it's a
to
question of
return.
what people would think.
However-
What people with vouchers would think. Would they really think, based on what they've heard, that, gee, this landlord is really a wonderful person?
Well-
No matter what the market does, this landlord is going to make up the difference and ensure that I can stay. That's-
Your Honor, I don't think that that would make the landlord a remarkable person. I think that politically, the developer had to sell this project as something that wouldn't displace people, or else there would have been more of an uproar than there is already about this project. So I think that they made a calculated decision to make a promise that everyone has the right to return at the commencement of the redevelopment process.
And I take your point that you could look at some of the statements about a guaranteed right to return as ambiguous, maybe potentially misleading if they're misunderstood to mean sort of an absolute right to return. I further take your point that if it really means you have an opportunity to return if you can afford it subject to market rates that are going to make it unaffordable to you, that might be a less valuable promise than it sounds if you're not familiar or not unpacking it. Take all of that, but it seems to me that the remedy, if that was the objection, was to seek review of the first stage order and say there were these vague promises about an opportunity to return. The commission did not actually enforce them. It didn't create an obligation to ensure return. All it does with affordable housing is require the Section 8, the 373 Section 8, and a little bit of inclusionary zoning. So the commission's order does not hold the developer in any meaningful way to, what you think a reasonable or fair understanding of its promises were. That's a reasonable line of argument, but one of my problems with it is, it seems to me it's an argument that could have and should have been made from the first stage order, and that it's problematically belated to be bringing it up now.
Well, Your Honor, I believe that it's not belated because the second stage order specifically retracts that right. It specifically retracts the right of voucher holders to stay at the property. And I think in review of a first stage order, the DCMR
When you say retracted, the first stage order didn't create such a right. In the list of things that the developer had to do, I thought there wasn't a part that said the developer must ensure that every housing choice voucher holder can economically be supported in a way that means that they'll be able to return and remain. That's not in the list of things that the commission required. So I'm not sure what the commission understood itself in the second stage order to be doing was explaining that what you were arguing was required in the first order was not required in the first order. And I know your argument instead is that it was in the first order and now it's being retracted. And that's one of the things we've been discussing is whether that's a right reading or the better reading or a fair reading of the first order. But if it's not a fair reading of the first order, then really the point would be that the first order didn't do what it ought to have done in your view, and that's again something that arguably ought to have been raised in a challenge to the first order.
Well, I believe that the second stage order, I take what you just said, but I also believe the specific deprivation of the right of large families and voucher holders in the second stage order, the commission themselves said that this was justified due to a balancing act. Yet the commission made no record to be able to understand the volume of displacement that would occur. So even if you're...
I'm sorry, but that really turns on sort of how you look at what happened at the first stage. And if you think what happened at the first stage is that the commission looked at this property and said, there are 535 units, 424, or maybe 490, some are actually occupied. We're only guaranteeing in our decision 373. Then at the first affordable units, then at the first stage, they have already made the decision that there will be displacement and there won't be one-for-one replacement. And so at the second stage, where they say, this is just block 7, there's still a continuing commitment to the project-wide 373, but now, with respect to block 7, let us make clear, building B, we're guaranteeing existing senior residence housing in building B, whether you're a voucher holder or a project-based unit resident, right? You get to live in building B if you want to, which then means that there's at least the potential to have more than 373 affordable units if you define affordable as the project-based units plus some extra voucher holders. So, in their view, it seems like the second stage order does more, right? If you look at it through a certain lens, there's no need to do any more fact-finding because they already made a decision at the first stage order. People will be displaced.
I don't think that they made that decision at the first stage order. I think at the first stage order, they made a two-pronged commitment, and the zoning commission acknowledged that
Well,
two-pronged
the hope,
commission and used it as a public benefit. And the intent and purposes of that order were clear that no one would be displaced. So I do not agree with the premise that at the first stage, there was an expectation of displacement. I believe the opposite at the first stage, that two-pronged commitment created an expectation that there would not be displacement. And that if we look at the first stage through the second stage process, if one of the lenses through which we're viewing that is that this second stage process has to comply with the intent and purposes of the first stage, and that there was that idea at the first stage that this would not displace, then the second stage order specifically depriving voucher holders and large families of the right and saying displacement is okay, does not flow rationally from, that finding does not flow rationally with the second stage conclusion that this property complies with the intent and purposes of the first stage, including that all residents on the property at the commencement of the redevelopment in 2018 would be able to return to the property through and following the redevelopment process. That does not talk about residents that may come, residents that may use the senior building, may not use the senior building. That is specific to residents that lived at that property.
They never seem to use the word able.
Excuse me.
They never seem to use the word able or ability. They don't say, I don't think, that either the applicant promised or that the commission expects that everyone living there now will be able to return or stay. But the words they use, this is what's given us so much trouble, I suppose you could say, are opportunity and right. And for reasons I guess we've talked about, there's a difference, because you may have the right to return or the opportunity to return, but you may not have the ability because the voucher isn't large enough, or your income situation has changed, or your family has split up and not everybody in the family can stay together in the available unit, or all sorts of things can happen. So with regard to the Section 8 situation, because that's, I guess, project-based, it's possible for the applicant to make a commitment. There will be 373 Section 8 units, subject to, and even that is subject to, the ability to contract with the government for it and the continuation of the program. But there isn't a comparable ability to guarantee that with respect to the vouchers. That's sort of the undercurrent, the context in which we're looking at that first stage order, I think.
Would you mind if I confer with Mo Co-Counsel for 1
Sure,
second?
and I'm going to give you a couple more minutes, then we're going to hear from opposing counsel, and we'll give you some time for rebuttal.
Your Honor, like I said before, I think that the opportunity, the parsing of the word the opportunity and the word the ability, I think doesn't do justice to what would happen if people were displaced from this project with vouchers. And I think that to parse the terms in that specific sense.
What happens if a voucher user loses her job and is unemployed?
If a voucher user loses their job and is unemployed, her rent goes to zero. So the voucher gives people.
It's 30% of zero.
Yeah, well, exactly, and the government would pay the payment standard. So there is a payment ceiling, a payment standard. The individual who holds the voucher pays 30% of what they make.
Is the current market rate for a voucher holder's unit higher than I'll call it the 70% ceiling that the voucher has?
The voucher, the limit that, so what
In
DCHA.
other words, if 30% turned out to be zero,
Yeah,
would the,
the payment to the landlord stays the same.
would it be enough to cover the market rent without the 30%, with zero contribution from
The 30%, there is a rent set. So say, just for simplicity's sake, say your rent is $100 per month, and you would pay 30% of $100. If you lose your job, that $100 still gets paid. The rent, the ceiling doesn't go down. It's just that the federal government now makes up the difference between what your 30% was and what the landlord was getting. So the point is, if a person with a voucher is renting a property and that person loses their job, the rent that that landlord receives does not go down because that person's income went down. It's just that the government's obligation to pay on behalf of that person
I
increases.
thought there was a ceiling as to what the government would pay.
There's a ceiling,
How high-
absolutely.
How low or high is that ceiling in comparison with the current market rate?
The ceiling at the,
Full market.
currently in the Brentwood community, I have, the
Is this-
documents here.
Is this in the record? Are these rent ceilings, which I take are neighborhood-based?
Yes,
Is that in this record?
it's not. No.
So it was not
it's-
presented, I mean, because there's a way that you can look at this and think, really, this should have been brought up in the first stage. And then there's another way to look at it and say, maybe this is actually, maybe you're not too late, maybe this is premature, right? Because this is just,
Well,
you know,
if,
the Block 7
yeah.
PUD, and there is this, it's not a commitment to remain in Block 7, it's a commitment to allow people the opportunity to remain in Brooklyn Manor as a whole, right?
correct.
And there are 3 more phases. And so the argument could be made, look, there are 373 project-based units, and then there are voucher holders, you know, many tens of them, you know, 50 to 60 families or unit residents. And so we need to make sure that their vouchers cover the market-based rent of these units once they're complete. But here we are in a stage, in this sort of interstices, where I don't know that it's in the record what the developer is charging for rent while the facility is under construction, what they're charging for rent for the swing spaces, what they plan to charge for rent once the property is fully developed. And so, I mean, maybe this displacement issue is speculative, because maybe there's gonna be a real estate bust, and everyone's rent is gonna just
Right.
drop precipitously.
And
I know that that sounds fantastic, and it likely is, but I'm just saying, we don't know what we don't know yet.
yeah,
So,
I would-
and given that the record doesn't have this information of what the expected rents are, what the current rent ceiling is in this neighborhood,
yeah.
I'm wondering how we can actually examine this issue.
Well, the issue has to be examined at this point because there's a deprivation of voucher holders' rights and family members' rights to live there. So if we move through this process.
Right now, I mean, is the claim that they're voucher holders, or that, I thought Ms. Elliott right now was still at Brooklyn Manor, and had housing, and I understand that her concern is, my ability to remain here is tenuous. I don't know what's
Yeah.
gonna happen. I don't know if my rent is going to go up above the rent ceiling such that my voucher is no longer good here. But she doesn't know that, and we don't know that.
Well, I believe that the injury that Ms. Elliott has suffered has happened. She's had her right as a voucher holder in a large family deprived from being able to remain at the property, should there not be appropriate bedroom sizes, and should the market rents exceed the Section 8 voucher holder level.
Are you representing that right here, right now, she and her family have been displaced?
No, but there is
I
a
thought-
threat because that right was taken from her through the findings, through the court finding that voucher holders and large families may be displaced. There is now a threat of displacement in the future, and that threat is concrete. As You've just articulated.
I'm not talking about standing, but I'm talking about sort of, the merits of, deciding whether or not she has injury or other similarly situated. It just seems like there are a lot of unknowns out there, and there are some gaps in the record.
Well-
And where the commission has said, we want more reports, and, these commitments are ongoing for the duration of the project. The arguments that you're making about being able to return seem to be arguments that could be renewed at a later stage when it becomes more clear what the situation is
I think
financially.
if we renewed them at a later, if we brought our claims at a later stage, if we get to the end of this property and Miss Elliott's displaced because, one, there's not enough large bedrooms, and two, their voucher holders, the market rates exceed the voucher holder limit, and I tried to make the argument that I'm making today, I believe the response would be, you should have raised that when the second stage order said that Miss Elliott was
Well,
deprived.
no one can say that because you have done, right? And any decision at this point would note that the argument has been made now, but might say that it was premature. So no one could hold that against you.
Yeah, I mean, I think that the way to move forward with this project, if we're complying with the intent and purposes of the first stage, is
I mean, you
to,
have a point, I think, if you are correct, that the second stage order, in effect, modifies and reduces or eliminates a condition in a promise or a condition of the first stage order, then that affects people's planning, it affects people's security in where they're living, and they're entitled to challenge that change if it's improper. Now, most of this discussion has been whether there really is a change or not, but if there is, if there really has been a modification of the first, a material modification of the first stage order, then I think, it's appropriate for us to address that now. Let us hear from the applicant's counsel. We will give you a reasonable amount of time for rebuttal when we get back to you.
May it please the court, Alana Russin for interveners, Mid-City Financial Corporation, Brentwood Associates Limited Partnership, and MCF Brentwood Village SC LLC. So just building off of the point Judge Easterly was just making, this second stage PUD for Block 7 is a perfect example of the affordable housing condition and the separate commitment in the first stage PUD working. No tenant has been displaced. That's,
I will ask members of the audience to remain quiet. Thank you.
it's an objective fact that the units scheduled for demolition in relative to this Block 7 PUD have already been demolished.
Is it an
Every
objective
tenant-
fact that's in the, are these facts,
Yes.
whether objective or not, in the current record?
Yes, I included the raised permits in the supplemental appendix. I'll find it in one moment. And it's in a footnote to our brief. I can find both sites for you. That occurred last year. Tenants who were in the 3 apartment buildings have already been relocated to other units on site, and therefore the condition and commitment have been met. Because those,
Sorry, one of the big discussions has been what was the original commitment? What does
Sure.
it mean? So why don't we, if we can shift to that, is it your client's commitment to provide an absolute right of return subsidized if necessary to all occupants of, occupants as of, measured as of the relevant moment of Brooklyn Manor?
I believe my client sees 2 separate parallel commitments. One is to include all 373 project-based units. In addition, an 11 townhouse units making a total affordable commitment of 384, as well as an opportunity to remain for any of the remaining approximately 55 voucher holders who wish to do so.
Right, and my
That is
question,
inherently
and my question is,
flexible.
what does that mean?
Yeah,
And
so I
the
think-
exact question I had was, do you understand that commitment to mean that if necessary, the developer will not charge market rates or will provide subsidies that mean that those folks have an opportunity, have an actual right to return that is not subject to the possibility that they'll be priced out of return?
So I think what that means is that there is a commitment to work with those voucher holders. And what that means specifically is, no, we haven't said we're going to cover this amount and subsidize above market, but this is an incredibly dynamic process, so I think it probably makes sense to take a step back and talk about how the Housing Choice Voucher Program works. So DCHA, the Housing Authority, sets a market rent annually for a huge number of submarkets. So within the Brentwood submarket, that market rent is reset annually. And that takes in all sorts of conditions and changes, right? Including the build out of 1,000 new units at this site. That it's sort of like assessing property every year.
Does that mean that, in fact, the development could result in a raise of the rent ceilings?
Exactly. And it's just hard to tell until we get there. So at this point, it really is premature to say we absolutely will cover the difference, because for all we know, there won't be any gap.
Well, no.
Is there
I'm-
any, sorry, is there any
Because-
data in the record about, because presumably under that theory, right, the projected development of 1,700 new units could have an effect even before the first brick is laid. Do we have any data showing an increase from 2018 or no?
We do not, another consideration right now is that the tenants right now are either under, the project-based units, which have a set rent amount through the federal government, or through the city. So I think those are slightly different amounts, but no, basically none of this is actually in the
What is the difference
record.
between the rent that you get from a project-based unit and the rent ceiling?
They're very comparable right
they're-
now, today.
Okay.
I'm not
Sorry,
sure.
what was your answer?
They're very comparable, I think within $100, something like that.
You know, the issue in a nutshell, it seems to me,
And I'm sorry, I should make a very clear point. I believe the client receives less than the market amount currently. But again, this is actually not exactly in the record. It's not in the record. And most importantly, this
if
has
I
been,
could just-
I'm sorry.
It seems to me the issue in a nutshell is, does the second stage order modify or in a material way the first stage order in the following sense? The first stage order is interpreted by Ms. Elliott and her counsel as incorporating essentially a guarantee that if you are a current voucher holder and you remain in good standing, you will have the right, opportunity, ability, you can stay there as long as you want. Sort of treating them like Section 8 dwellers. And they argue that the second stage order, the commission has modified that or taken that guarantee away and explicitly stated, well, if the rent gets high enough and the vouchers don't cover it, then they will not have that right, opportunity, ability, whatever the precise word is. And that's okay with us, the commission says. We recognize there's that possibility that the voucher holders will be displaced, and we say that's okay because the benefits of this project are so great. And the question I have for you is, are they right when they say there is that modification of the first order in the second order?
No. And I think there's two specific places in which the commission makes very clear that that is not the case. It's It's in conclusion of law 4 in the second stage order.
Give me the page if you wouldn't mind. so that I
Absolutely,
can
it's
quickly
page
get to it.
50.
Excuse me?
50 of the second stage order. It's a fairly long paragraph. It's about halfway through the paragraph on page 50. The sentence that starts likewise. Likewise, the applicant did not request any changes to the project's benefits and amenities package, including its proffered affordable housing commitments.
Well, no, the commission says that, but the issue is the commission right to say that?
And then turning to
Which
the.
turns to the first stage order, really.
Well, so I think that there's sort of 3 sections of the second stage order that we're looking at. One is findings of fact, which is what opposing counsel relies on for saying that there are actual benefits that were taken away or that the first stage was somehow modified by the second stage. But that's, I don't think, accurate because, again, findings of fact in this context within a zoning commission order are summarizing the evidence presented. And the zoning commission has an odd requirement here where they need to both address every contested issue, even if it's not accurate or even if it's not yet ripe, which they have to do in the findings of fact. Once they do that and go through the record and discuss everything that has been raised, including perhaps a request from an applicant because it wasn't included in the first stage, but a request at the second stage to cover the difference in a voucher if eventually the voucher amount doesn't support market rents. The commission said no and explained why, but that doesn't mean that that was any modification of the first order.
Was
And
it,
so-
is there anything that you can point to in the record of the first stage proceeding, whether it be the order or transcript or some submissions, that clarified what this notion of an opportunity or right to remain or return meant, and that it did not mean that, you know, no matter what happens, we will honor your voucher and you'll have a unit?
No, I think it's, I
So that
think it-
remained unclarified in the first
exactly.
stage
I think it is
proceeding?
purposefully unclarified to give some flexibility at each of the second stage approvals. But it is baked into condition B
Well, wait a minute, what does that mean purposely unclarified?
to give some flexibility about how it happens. The
If you don't
actual
mind.
commitment is very clear.
Well, can
Sorry.
let me ask you a related question, which is, if what you're saying is right, which is what the developer was willing to do at the first stage was say, look, there's an ironclad guarantee for the 373, and there's a little bit of inclusionary zoning. That's what's guaranteed. There are a group of folks who have housing vouchers, and we can't give them an ironclad guarantee because it's a dynamic situation. It wouldn't be economically possible. But we represent to, you know, here's our plan. We're going to do the following things. We're going to try to minimize displacement. There might be some displacement. We don't really know. And the commission had said, that's a situation. We understand that situation. There might be some displacement because we can't guarantee return. The developer won't do it. We're not going to insist on it because on balance, the benefits are better. It's not reasonable to insist it. You know, that would be a first stage order that would have clearly laid all of this out. And the first stage order doesn't really have a lot of that. And my question, that's a big wind up to the question, which is there anything in the first stage order where the commission says, we recognize that the conditions we are imposing at this stage leave it possible that there will be some displacement, but on balance, we think that's okay? Is there any place where the commission even acknowledges in the first place order that there might, at the end of the day, be displacement because of uncertainties about what will happen with housing voucher folks?
I don't think the commission explicitly says that sentence. All it does.
Or
is-
anything that, I mean, I don't mean verbatim those words. Is there any place in the order you can point to that shows that the commission, when it imposed the requirements that it imposed, recognized displacement was a possibility, but ended up concluding that on balance it was okay, which is what they did explicitly in the second stage order. Is there anything that is at all like that in the first stage order?
So again, I'm not sure that that's explicitly what the commission did. I understand that
Again, you're using the word
Okay.
explicitly. I'm just asking, is there anything anywhere that implicitly or
Well,
otherwise suggests that the commission at the first stage order recognized a possibility of displacement but thought it was okay on balance?
I don't believe so, but I also am not certain that that is exactly what happened in the second stage order, that there are findings of
I'm asking right now
fact-
about the first stage order.
Okay. I think the commission understood the demographics because it had significant information in Exhibit 104 to the first stage order of what the current units were, how many of them were occupied, who lived there. They took all of that raw data, understood it, and set condition B that they set, which is the affordable housing condition, saying there will be 373 plus 11. Now,
Let me
there's.
just ask this way. Let me ask it this way. Do you think what in the first order would lead a reasonable person to conclude that it was part of the intent and purpose of the commission in entering that order that there might be some displacement, but that whatever degree of displacement might occur would be small enough or otherwise would be outweighed by the benefits of the plan as it was proposed at that time?
I believe, again, all I can say is that there were provisions put in place to prevent displacement.
Prevent?
Yes,
You mean to,
through the second stage orders. But I think it is absolutely crucial to understand the interaction of the first stage order and the second stage order, because each of, right, the phasing of this development is the prevention of displacement. That the way that this happens is that there is a tenant relocation and construction plan that is revisited at every second stage PUD. That is a condition to the first stage order.
I'm sorry,
So
is
it's
it your
baked
view
in.
that the current development will absolutely prevent displacement?
That the goal is to prevent
But
displacement.
is there a guarantee that it will prevent displacement?
There is not a guarantee. But the goal is, and I think that there's some odd imputing of some nefarious intent that is just, one, absolutely not there, and two, there's provisions in place to prevent displacement at each subsequent stage, right? Because there are 4 phases of construction. At each phase of construction, there has to be an updated
I keep getting hung up
demographics.
by the word prevent unmodified. I mean, I gather there are provisions intended to try to prevent displacement, but the commission did not require that there be no displacement.
Exactly, and so,
And the developer is not assuring that there will be none. There is a guarantee of, 373 plus 11 or 14, whatever the number is, and a representation about an effort to try to prevent displacement in various ways. Is that a fair description of what's going on?
yes, I also think it's important to look at the actual numbers and the way in which this is phased, right? You're looking at 1,760 units total. The number of people that could even potentially face displacement that is not going to be a reality are 55 today. That is just a very small number of people to individually work with, and that was the idea, that this is happening over a 10-year period. Some portion of those 55 people are probably not going to be interested in remaining. There will be multiple ways to solve this, including assisting in home ownership, buying one of their for sale units. There are just too many variables, but the interveners have always considered that they have 2 concurrent requirements, commitments, promises, conditions, however you want to look at it. The maintenance of the 373 project-based, the 11 IZ units, and working with the remaining voucher holders who want to stay on premises. There's just no simple one-size-fits-all answer to how that happens.
When I read paragraph 102 on page 41 of the second stage order, which is the paragraph that contains the heart of the issue here, it begins by saying that the Tenants Association alleges that because there are current residents who receive financial assistance through the HCV program, the Housing Choice Voucher Program. A different program from the Section 8 program. And the applicant has not provided an assurance that future voucher payment standard will be sufficient to cover the future market rate rent level for the project. The applicant cannot meet its commitment to house all residents in good standing at the commencement of redevelopment through and following the redevelopment process. That's the premise for their objection here. And that interests me because that suggests that the association has always known from the get-go, that is to say, from the first stage proceedings, that the applicant has not provided an assurance that future voucher payment standard will be sufficient to cover the market rate. And therefore, that the applicant has always known that the commitment to an opportunity to a right to return has always been subject to that limitation. Is that a correct reading in your view? I'll ask the same question of Mr. Merrifield when he returns. Is that a correct reading in your view? Because this is important to me because it seems to me that if the tenants understood at the time of the first stage proceeding that there is no actual guarantee of ability to return because, for example, the vouchers may not be large enough to meet the market rate, then that undercuts their argument that there's a change here between the first stage order and the second stage order. On the other hand, if that's something they didn't always understand for some reason, maybe a legitimate reason, then it can be said there is a change, a modification, as it were, between the first stage and the second stage order. You see what I'm getting at?
I do. I think the only way that there can be an argument that there was a change between the first stage and the second stage with respect to the developer providing an additional subsidy, because that's really what we're talking about in 102.
That's where it would come down to, right?
Right. That was never a condition to the first stage PUD. It actually doesn't even come up in the first stage PUD. So therefore, I don't understand how somebody could take the first stage PUD and say, oh, well, the developer will absolutely provide a subsidy above. And again, this is very theoretical. This is conjecture about what the market will look like in 10 years. So no,
But
that
you
isn't
say
a
it's
commitment they
theoretical,
wouldn't have.
but I mean, if you could see why a tenant would be very interested in trying to get the zoning commission to provide that assurance. Because in theory, I mean, it might be a problem, might not be, but you'd like to be guaranteed that it won't be a problem. And you could see why the commission would, if the issue was squarely teed up to it, the commission would have to think through. Well, on the one hand, maybe no one will be displaced. It might all work out economically. Maybe a few people will. There's going to be a much better, more modern set of units. There'll be a bunch of affordable housing, other benefits on balance that would be worth it, even though it's not an ideal for some people. That might be a good judgment for sure. But the fact that it's uncertain doesn't mean that it isn't a reasonable condition for the tenants to want and for the commission to consider imposing, right?
Certainly, if it was raised, but it was not raised at the first stage, so it wasn't included as a express requirement or request.
What do you think of for example, if you look at the first stage order on page 44, this is a discussion of the ANC's proposed conditions and how the applicant responded. And it describes, with respect to tenants' right to return, condition number 3, it says, the applicant will allow all qualified Brooklyn Manor residents at the time the redevelopment commences the ability to return to New Brentwood Village. Is that an accurate description of what the applicant responded to the ANC? Because I haven't tried to excavate that.
Sure, I'm sorry. Can you again point me just to the reference?
I'm sorry, it's
We're in
page
the first-
44 of the zoning commission's first
thing.
order. It's, looks like, well,
It's the middle of the page, condition number
Okay.
3.
yeah, it's the,
Right, I think that is absolutely an accurate representation, and
and what is that, what is it that the applicant is promising? What does that mean?
well, again, right, we're trying to parse what ability versus opportunity versus,
Right, I'm just asking,
Yeah.
so, the ANC is saying, support is
Yeah.
very important in this process, is saying, look, applicant, we've got some problems here. The applicant's responding, saying, don't worry, we will allow all the qualified folks the ability to return. And I'm just asking you, what does that mean you were telling the ANC you were promising? What does that mean?
exactly what we're saying there, that at each subsequent stage, we will assess how many voucher holders there are, what units there are, what the unit needs are, what the market rate is, and make room for those tenants. But it's,
I'm sorry, make room if financially possible.
yes, I mean, there's too many kind of factors going on there. But just
I
because
have to
the,
say,
just
when
because.
if I was reading that language, I'm not sure what would leap to my mind is, we'll make judgments down the road, and maybe they'll be able to come back, and maybe they won't, depending on how
Well,
economic factors.
that's not exactly it, but what you're saying.
Well, I'm just
there
asking,
is
if you were going to try to say in simple words, what is it that the developer was
That every
representing to the
voucher
ANC
holder-
that you were promising?
Every voucher holder has the opportunity to return.
But is the issue that the developer does not want to make some sort of promise to voucher holders citywide? Right? I mean, that you are indicating some sort of commitment to work with individual pre-existing
Exactly.
tenants with vouchers to figure out the numbers, the rent ceiling, based on the particular point in time that they're moving into a unit, but everything is gonna be one-off and tailored to that individual pre-existing tenant so that you don't have to you're not making any commitments to voucher holders elsewhere in the district? Is that what's going on? I'm trying to
That's part of
understand.
what's going on, but basically, it was just that.
I'm sorry, I didn't hear
Yes,
yes,
yes.
that is correct.
That is a component, I would say. But really what was going on was there was dialogue with the ANC, and there was essentially fear that this was being used, that as a part of the overall development, which again, coming back to this, we're just talking about the second stage PUD here and whether or not there was displacement as a second stage PUD. But looking at the overall development, because that's the first stage, that there was no intention to force voucher holders out. But again,
I'm just wondering why, I'm sorry to interject, but why there isn't an opportunity for some sort of settlement here if there is a commitment to work with each individual pre-existing voucher holder right here, right now, that you are making to this court that could be memorialized in a written opinion, why there couldn't be a meeting of the minds between the parties. And perhaps you're willing, and I'm not trying to put, words in I'll ask opposing counsel as well.
sure, I think that is certainly something that interveners would have considered and probably have approached. There's a lot of factors going on, though, including the concurrent federal FHA case. But I think as far as I understand that, I can't speak for opposing counsel and what their requests have been in terms of settlement discussions, but excellent point. I think that's a reasonable, at least inquiry. But I don't necessarily know where they stand and where we do in terms of what you're talking about, which is essentially more of a individual and monetary settlement versus altering the unit mix, correct?
Well, I was just responding to the response that you gave to my question, which is what does this opportunity to remain mean? And my understanding was your answer was, well, we really do want to make a commitment to people who are actually there now with vouchers and in real time make accommodations for them, given the current rent ceiling, that will allow them to stay in the units that are available. Is that? a fair
Absolutely, that's a
characterization
fair-
of what
yeah.
you're saying?
And as far as I understand, the opposing counsel and his client have always been looking for 535 units and 4 and 5 bedrooms, not an individual person by person, family by family resolution.
I'd like,
So-
oh, I'm sorry, I thought you finished.
Thank you. You know, again, I just think that this is, the scope here is Block 7. Was any tenant displaced by the second stage PUD approved for Block 7? No. Was there any alteration to the affordable housing commitment contained in the first stage? No. That the concurrent parallel commitments are still there. One is the project-based units, the other is to accommodate voucher holders at each stage through the tenant relocation and updated demographic data at each second stage PUD. There has been no change.
I'd like to ask you about 2 other arguments to which Mr. Merrifield alluded at the beginning of his argument. One of them was concerned what happens if, for example, a senior living in a multi-generational household, either paying rent under either a voucher senior or a Section 8 senior, decides to separate from that household and live in the senior building. Where does that lead? Now, that senior can do that and have a nice, and continue to use the voucher or the Section 8 entitlement in that senior building. Where does that leave the rest of the family who can't go into that senior building with that senior?
Well, where the senior is the voucher holder, that is that senior's choice, whether to go into the
So if
senior
it's a
building and
voucher
use that,
holder,
or to keep the voucher and use it in the multifamily in a unit that would be appropriately sized for
Now-
that family.
And so that potentially could lead to some displacement. But there's nothing in the first stage order that precludes that, because as far as voucher holders are concerned, that's the senior who holds that voucher.
Exactly.
Now, what if it's a Section 8 situation?
The project-based?
Yeah, in the same example, I just want to know, because this was the third point he raised in his oral argument. What if the senior is, what if the senior in the multi-generational family is living in Section 8 housing at the current, together, and the senior decides to leave them and go live in the senior housing?
I don't think that there's a difference whether that payment is under the Section 8 project-based
is
or
that
the
right?
housing voucher.
I thought those two hypotheticals led to different outcomes. I thought that if a senior who was a project-based unit resident was living with family now and didn't want to move, didn't want to be separated from his or her family, could opt out of the senior housing in Building B, and under the second stage order was guaranteed a project-based unit in somewhere else in the development.
Correct.
Okay.
And the reason that I'm not differentiating between the project-based and the housing choice is because, again, the developer sees it as their commitment to house.
So pursuant to the conversation that we had
Exactly.
just moments ago, you would work with the
Correct.
voucher holder in the same situation to ensure that the voucher holder, the current resident voucher holder, had housing
Correct.
elsewhere in the development.
What about the rest of the family? If the senior in a Section 8 housing leaves the rest of the family and says, I'm going over to you young people have been causing me to tear my hair out, I'm going over to the senior housing where it's nice and peaceful. Where does that leave the rest of the family in terms of their right, opportunity, ability to remain at the RIA.
If the remaining family is not a voucher holder or a Section 8 holder, then there isn't that, they don't fall under the umbrella of the commitment.
Okay.
Can I ask
The
you,
other-
do you, you mentioned a number of times that the developer feels as though it has a commitment, voucher
Yes.
holders to work with them and try to ensure that they're not displaced?
Yes. Which,
Do you, what do you think the zoning commission has required the developer to do on that front? Current order, and
So-
the first order or the second order?
the way in which the zoning commission did that was to bake it into the tenant relocation plan process at each second stage. That those are two different commitments under condition B. You both have to provide the total number of project-based units, and at each second stage, you have to provide new demographic data and a new tenant relocation plan that addresses this second commitment.
Well, I'm sorry, the commission says that that new information has to address that
Yes.
commitment? And how, and again, what is that commitment? If you were gonna say, if we're gonna write an opinion that says, here is what the developer acknowledges, it is required by the zoning commission to do for housing voucher holders, what are the exact words you would say your commitment as imposed by the zoning commission is?
To house a voucher holder who wants to remain in a unit through and following redevelopment.
Without regard to the economic, including, if necessary, providing subsidies?
Perhaps. I mean, I
Perhaps
understand that you want.
is not the best commitment term.
I know, and I understand that you want that to be,
I don't want it to be anything. I'm just trying to make sure
Or
I
they-
understand what your position is.
but it isn't that,
Right.
it isn't cut and dry, very specifically, so that it's
Right.
designed to work with each individual.
But I just want to make clear, that's talking about what the zoning commission ordered you to do
Correct.
in either stage 1 or stage 2. But as you stand here and now, you would be willing to work out an arrangement with Ms. Elliott and other voucher holders to make personal individual commitments to them to stay. Is that, that's what I understood you to say earlier, and maybe I was
Yeah, yes.
foisting something on you.
Well, it's,
There's the question of what the zoning commission maybe said.
Sure.
And there's a debate about that.
right, I would
I'm
categorize
trying to
it as,
figure out if there's actually, the commitment that you have made would translate into dollars and cents. You're willing to work with current residents who are voucher holders who would like to remain.
yes, and it's also baked in, yes, comma, it's also baked into the process, because we have absolutely committed and will continue to commit to do that at each phase of the development. So yes today, yes tomorrow, yes in 10 years.
Do I understand correctly that one thing that Ms. Elliott is arguing is that the applicant was required to come up with updated demographic information in connection with the second stage PUD and failed to do so?
I believe that is an articulated argument, and that is just incorrect. That, at Exhibit 1.
What do you cite in the record on that score as far as the updated demographic
Yes,
information?
we included it in the supplemental appendix. It's Exhibit 179 to the second stage PUD process.
Now, this relates in part, or maybe in whole, to the third argument that they've alluded to today that I wanted to ask you about, which has to do with the number of four and five bedroom apartments and, for that matter, the number of three-bedroom apartments that are planned or contemplated as part of the second stage PUD. Their argument, as I understand it, is updated demographics would show a greater need for that than is contemplated by the second stage PUD. Is that, do I have that correct?
I
or-
don't believe so. I think what their argument is that the entirety of the project, so including every,
Well, it's true, because I asked him about that earlier.
yes,
Yeah.
not this second
So,
stage.
but isn't this the time for them to raise the question if you're supposed to provide updated demographics? or no?
Well, they have,
Right.
and we provided it.
And you think the updated, what is your view as to what the updated demographics show on this issue?
That everything that that the applicant provided in the first stage PUD was absolutely accurate, including the projections. Because as a part of the demographic information in that first stage PUD, at that time, there was about 490 occupied units. We forecasted based on natural attrition, people moving away, people passing away, people making various changes that occurs in rental housing, that at the point of the first development, we would have 424 occupied units. We currently have 428. So I would just say
One
it's
thing that
absolutely,
struck me, one thing that struck me was that going back to the first stage, the data seemed to show that there were extremely few families occupying 4 and 5 bedroom apartments who actually needed all that space in terms of the size of the family.
correct.
There were small families in large 4 and 5 bedroom apartments. That was the data back then, as I recall.
Absolutely.
Is there some argument being made that, well, that's not the data today, and in fact, there's some sort of increase in the large family, in the number of large families who need more spacious apartments?
No.
Is that,
There's been no argument that the actual demographic information, that is, these are the units, unit sizes, occupancy, and families who occupy them, is incorrect or
no, I think Ms. Elliott is arguing that, well, the commission should have dug deeper to find and learn more about the demographic information than it did. How do you respond to that?
I think they dug very deeply, and the zoning commission,
I'm talking about at the second stage.
they had the information. They requested it and they received it. The information being, this is the current demographics of who is at Brooklyn Manor, and most importantly, for this second stage PUD, in the demolition of these 3 buildings and the construction of 331 new units, no one will be displaced. There's 1 tenant remaining, that was Miss Elliott, who's now been relocated. They dug appropriately and completely deeply for this PUD.
Okay. We will let you sit down. Thank you.
Thank you.
And we'll hear from Mr. Merrifield. Ms. Merrifield, about 5 minutes.
Thank you, Your Honor. With respect to the demographic information and the bedroom sizes, that we would argue that that does remain an issue outstanding. There was, as counsel referred to, there is a case in the District Court of the District of Columbia based on the Fair Housing Act that says that the elimination of the 5-4 and some of the 3-bedroom apartments through this redevelopment constitutes familial status discrimination. And as part of that case, there is demographic information. And that demographic information has been sealed as part of that federal case. But at the second stage of this
Why
zoning,
was it sealed?
it was sealed because the Mid-City has requested it to be sealed, I assume. So what the party opponent asked at the second stage of that hearing was that demographic information that exists now, that we know exists because it's under seal in a federal court case, that the zoning commission should have asked for that demographic information. Why we think that is so relevant is because there was a memorandum of a decision filed in that case, and this is part of the record pursuant to the motion for
Did you-
reconsideration.
Well, wait a minute, hold on. I don't remember reading anything in the briefs. Now, maybe I missed it. But I don't remember reading anything in the briefs about a request being made to the zoning commission to look at this demographic, or to request this demographic data under seal that was denied by the zoning commission. I don't remember a claim being made that the zoning commission erred in denying that request. Is that an issue in the briefs?
The issue under seal, the issues under seal, that was raised, I believe that's my argument in the brief, that there wasn't sufficient fact-finding done.
Well, I remember that argument.
Yeah.
But I don't remember anything about saying, we requested the commission to take whatever steps were necessary to acquire this particular data that exists over across the street. And they did refuse to do it, and we're appealing that refusal. Is that in the briefs? If you tell me it is, maybe I.
There was a motion for reconsideration filed. If we look at the briefs as the argument in the brief that appropriate demographic information wasn't taken by the court, and we contextualize that to the second stage hearing process, there was a motion for reconsideration filed.
Well, I remember the general statement that there should have been more, the commission should have gotten more demographic, but I'm asking you whether you preserved the claim before the commission as to something the commission should have done that the commission declined to do. And I don't know that having to do with this.
Having to do with the
Information on the
brief
seal.
specifically, Your Honor?
Well, that's how we get issues.
Yeah, I mean, I would argue that that issue is appropriately before the court because the issue was raised in the brief that there wasn't appropriate fact-finding by the zoning commission to make a decision that the displacement of families and voucher holders was acceptable given the public benefit because they didn't collect this information. This information that they knew was
Did you
available.
offer them any information that expanded on the information that the applicant gave them? The commission doesn't,
Yes,
you know.
through a motion for reconsideration. Through a motion for reconsideration, they came out after the hearings were set. There was a motion for reconsideration filed, asking the court to take notice of a recent decision in the in the federal court in the District of Columbia that noted it was a class certification. And it noted that the plaintiffs in that case had convincingly enough argued to that judge that there were upwards of 130 families that could be displaced by this project if it moves forward with the current bedroom layout. So what we asked the court to do through the motion for reconsideration is to remand this case back, open it back up, and ask for that information to be brought to the zoning commission so that they can make a finding of fact while weighing the updated demographic information that two experts now, Mid-City's expert and the plaintiffs in that case expert, have reviewed. And those two experts
I'm
come to
getting
very
confused
different conclusions.
procedurally. You're referring to a motion to reconsider, and then you're also referring to something you asked the court to do. I know you had filed a motion to supplement the record, and there are a series of letters relating to bringing information in front of this
Sure.
court that the court hasn't ruled upon, as far as I know. Is that what you're referring to, or are you talking
No,
about the motion to reconsideration in front of the zoning commission?
I'm sorry, for in the motion for reconsideration.
Filed in the zoning
itself,
commission,
That was filed at the second stage level,
right, in front of the zoning commission.
in front of the zoning commission.
I think you may have misspoken.
Sure,
Misspoken
yeah.
and said court, so I was uncertain
I-
whether you were
I-
referring to the
I
letters.
kept on doing that in my
That's
mood
fine.
sessions too,
No, that's-
yeah.
I was unsure whether you were referring to the letters in front of us or a motion to reconsider in front of the
Correct.
commission.
Yeah, so I apologize, Your Honor. The motion that was in front of the commission asked the commission, look, there's this memorandum of opinion that just came out certifying a class. And the basis for certifying that class is it says a lot of families will be displaced by this project. I think it was upwards of 500 actual individuals, people, could be displaced by this project if it moves forward as it's planned. So we asked the court to vacate the second stage order in order to reassess, in order to ask for that demographic information that is under seal in the federal court case, and then to reassess whether this case still complies with the intent and purposes of the first stage order not to displace anyone.
Well, nobody's being displaced by the second stage order.
The Block 7,
By the Block 7 PUD.
the Block 7 PUD is key to what this project will end up being if these issues aren't dealt with. Because the Block 7 PUD, if pursuant to, if there is no guarantee for vouchers holders, which we obviously disagree with, and the senior building is built, that will be 200 of the 373 affordable units will be held in the senior building. So there will be, and people in that senior building won't all be the people currently living at Brooklyn Manor. I believe pursuant to the supplemental
That's not correct to say that 200 of the 373 units will be will be either in the senior building or in Block 7. That's not correct, because not all of the 200 units in the senior building will be Section 8 units. Many of them will be voucher units,
But if there is no guarantee for voucher holders, Your Honor,
but that's.
there
that's a
has to
different issue.
be, they have to be project-based units.
Well,
That
no,
means,
I'm sorry, I just want to be real clear. My understanding is post the second stage order, if you are a senior and you live in a project-based unit or have a voucher, you can live in the senior building. And you can also, if you are a project-based unit resident who's a senior, opt to live outside of the senior building. And so, again, to say, you know, to get more granular with Judge Glickman's question, it is not true that the 200 units in the senior building will all be Section 8 housing units.
which you just articulated, Your Honor, the ability for seniors to choose to either live in the senior building or live outside the senior building is only true if voucher holders are able to access the senior building.
That's what the second stage the second stage order says.
But this, and the second stage order contradicts itself, because it also says that voucher holders don't have a right. It also makes a finding that
No, I'm
voucher holders do
sorry.
not have a
I
right
think
to
if
live at
you
the
look-
property.
Excuse me, if
Sure.
you look at the very, you know, what is ordered, and certainly what any court would find is that any senior voucher holder or Section 8 unit resident can live in Building B. That is what Mid-City has said, and that is what the second stage order says. And maybe that is not enough, because that does not protect other voucher holders. But what we've heard here today is at least, I think, an opportunity for a further conversation about other voucher holders. And what I hear is that Mid-City is saying, we are willing to have a conversation with you about settling this such that other voucher holders who are not seniors, because senior voucher holders are protected if they want to live in Building B. So you have that, and you're building on that. And that is more arguably than the stage 1 order guarantees, right? So the question is, are you interested in having a conversation about negotiating for rent ceilings for the other 50 to 60 current residents? And
Your Honor,
It
yeah,
sounds like
Your Honor,
Mid-City is
yes.
interested
We-
in having that conversation
We
with you.
proposed at the second stage in a
I'm
supplemental.
not talking
agreement.
about what happened before, I'm just,
But
I'm
yes,
putting,
we've
I'm
pro-
putting it out there.
Yes,
I would
absolutely. I
recommend
mean-
against, negotiating against yourself.
I'm not,
You
I'm not,
have,
I,
right here, right now,
My-
according
yeah.
to Mid-City and the second stage order, a guarantee for all seniors, voucher holders or project, or Section 8 unit residents to live in the senior building. They are protected.
absolutely, Your Honor, we would love for that to negotiate that. Like you said, that's already in the order. What we are asking for at this stage is the commitment for all voucher holders. Because
and
as
I
you point
understand
out,
that that's the delta that you
Yeah.
are very concerned about. It just sounds like there's an opportunity for a conversation there.
sure. But, so, I mean, whether or not voucher holders will be able to access, as the judge points out, clearly pursuant to the order, seniors with a voucher would be able to access that building. I would argue that the order contradicts itself, and it must be, this case should be remanded so that that contradiction should be resolved. Because that order that says that seniors clearly can stay with a voucher contradicts the other order, the other finding that specifically says voucher holders can be displaced. So
Where,
that
I'm
needs
sorry,
to.
do you want to point out to me, just in the text, the contradiction that you're pointing to?
Sure.
Again,
Your Honor,
I don't see that this is in your interest to point out this contradiction, but
Well,
I'm curious to see it.
I mean, as part of the second stage order, the second stage findings of fact, which I've argued, they make 3 determinations. And
Well, you
on
don't make
page,
determinations and findings of fact.
Well-
I guess is the first response to that observation.
On page 41, paragraph 42, they specifically find that the applicant, Mid-City Financial, does not have a obligation to house voucher holders at the property. Now, that contradicts the condition you had just read that says that seniors with vouchers will be able to access the senior building. I'm not trying to argue against myself. I'm just trying to point out to the court that this order contradicts itself. And if we could resolve this, with a conversation, that would be great. I just want to make clear to the court that although that is in that specific order, what you had just raised, Judge, that there's also this contradicting finding, paragraph 102, that says that voucher holders aren't guaranteed a place. And if they have to leave, then they have to leave, and that displacement is acceptable. And that was the point the reason why we sort of went down this path was because Judge Glickman had raised the issue of the importance of Block 7 to this PUD, and the importance of Block 7 is because this order contradicts itself, if the court found, well, there is no right for voucher holders to live in the senior building because there's no right for voucher holders in general to live at the property, then 200 of the 373 units pursuant to the affordability covenant would have to be project-based units. That was the point I was trying to make.
I urge you to look at page 39 through 41, and the commitment to the families with seniors precedes the discussion of the voucher holders. And I would think it would be in your interest to say that solidifies the zoning commission's views on what seniors are entitled to.
My view is certainly that seniors are entitled to live in the senior building with a voucher, absolutely. But what I will say is that it is
And that
it is a bit
Section 8
unclear in the order.
seniors in Section 8 units are entitled to live outside of the senior building.
Sure, but this is where we get to an issue with the numbers and whether or not we will have the appropriate amount of numbers to house everyone that needs to be housed at this property.
Right.
Because if Ms.
And what
Elliott has
Mid-City
to,
has said is they're willing to have a conversation with you about guaranteeing that each and every one of the folks who are not covered as a senior, as a Section 8 project-based
holder?
unit resident,
yeah.
right?
Well, the project,
One of the 373, or as a senior, that they are willing to talk to you about individual accommodations to ensure that rent ceilings are within their means with their voucher.
and we would absolutely love to have that conversation with respect to the project-based tenants and the voucher holders that are senior citizens. But as you just pointed out, Judge, that's already in the order. What we also think is in the order, what we also think is the commitment from the first stage is for all voucher holders to be able to stay at the property through and following the redevelopment process.
Well, when you say following, are you taking the position that if you're a voucher holder now and the applicant says, we've got a deal, you can continue renting here this year, and the lease is for a year and you're good to go, that the voucher holder could say, well, regardless of whatever happens in the future, regardless of whatever happens to my income, whatever happens to vouchers, whatever, I have a right in perpetuity to remain here and subsidized if necessary by the applicant for the rest of my life? Is that your position?
I believe that voucher holders, the commitment was that voucher holders could stay at the property following the redevelopment until they choose to leave. Yes.
Forever?
Yes, absolutely. And I believe that if this project would have been put forward to the public as every voucher holder's got to go, that it wouldn't have been passed. And that is where I think the promise made at the
Well, I mean,
first stage.
it's one thing to say, we're making these changes, and when we make these changes, everybody who's here now can stay here. It's another thing to say that, and for the rest of their lives.
Well, I mean, Your Honor, this is the preservation, again, to move to the housing elements of the comprehensive plan. This is one of the points in the comprehensive plan. One of the housing elements is not just preserving subsidized units, but also preserving market rate units that are affordable. And the reason why that's a part of the comprehensive plan, a housing policy of the comprehensive plan, is so voucher holders can remain in these neighborhoods and not move to hyper-segregated neighborhoods. If, as part of the record on the first stage was a study done by George Mason University, which points out where voucher holders are, and they're mostly in the most poverty-stricken areas in Washington, D.C. And the reason they are is because they get priced out of redevelopments like this, because a developer makes a promise that everyone can stay who has a voucher, and then a commission at the second stage says that that promise actually doesn't guarantee you, voucher holder, the right to stay. And that's why, to your point, Judge Easterly, absolutely. I would love to agree right now that seniors have the absolute ability to stay. But I also think it is absolutely clear that that right extended to families with vouchers, like Miss Elliott, so she doesn't have to choose between her family being gone and living in the senior
Who
building.
has the voucher, an individual or a family?
A head of household.
So the head of household. So if the household splits up, some members of the household, the ones who don't have the voucher, the ones who are not the head of the family, or are not with the head of the family, by definition lose out and get.
The family members. So Miss Elliott would have to make a decision.
Right.
Do I go to the senior household and preserve my right to have a roof over my head?
But if Miss Elliott decides to go over to the senior building, then are you saying there's anything in this order that protects the people in her family who do not have either vouchers or Section 8?
No, I think the order makes them tossed to the wind. The order specifically says,
The first order.
the second stage order.
It sounds to me like that's true of the first order as well, from what you're saying.
I don't believe so, because I believe the first order said that every resident on the property at the commencement of the redevelopment would have the right to stay.
If
So
that's what it says, then the 373 ceiling doesn't mean anything.
absolutely. And that's why it was a 373 and commitment. It wasn't a 373 or commitment. It was 373 units and the ability of every resident on the property the right to return. And Judge Easterly, you had asked for something from the transcript to show a commitment from Mid-City. And I would point to the May 11, 2015 transcript that was part of the second stage hearing, that there was a question from myself to Mr. Mears, and I said, with respect to the right of return, starts at paragraph, or line 5, you guaranteed earlier a right to return for everyone on the property when construction commences, correct? Mr. Mears answers yes. Mr. Merrifield, okay. So if you could only guarantee 373 units, as you testified earlier, how can you commit to bringing everyone back to the property when the construction commences? Mr. Mears' answer, we committed that we would have 373 deep subsidy affordable units, and we'd work with all DCHA voucher residents and the Housing Authority to accommodate them also. That is an and commitment. That is 373 units and voucher holders' ability to stay.
We will work to accommodate.
We will work to accommodate. Yes, I believe that that is selling and promoting an intent that no one will be displaced, and that intent,
That's different from, to me, to my ears, that sounds different from, and they will have a right or a guarantee, or we are sure that there will be a place for them.
I don't think if,
Or that we are sure that an accommodation will be reached.
I don't think if a representative from Mid-City was talking to a council member or residents at this property, and they said that would be taken in any other way than saying, they're gonna ensure no one gets displaced from this property.
It doesn't
Voucher
sound like
holders,
insurance to me.
well, excuse me, sorry.
That's not how insurance agents talk. They don't say, we'll work to accommodate you. If you die, we'll work to see if we can get you.
This is not, I mean, this is a community, this is an elementary school full of children possibly that would be displaced if voucher holders and large family members are
Well,
able
I'm
to be
just struck-
displaced from the property.
Maybe I'm naive, but I'm just struck by the magnitude of what you're saying. If you have a family living in, whether it's Section 8 or voucher, the head of the family, let's say, is the wife, and she and her husband are living there under her voucher or under her Section 8 entitlement, and they divorce. The position you're taking is that, and they're not going to live anymore in the same unit. The position you're taking is that the wife can get to stay in a unit there, but also the husband who's leaving that unit also will have an entitlement to remain at RIA. That's the position you're taking. I find that surprising, I think. Maybe
that
I'm-
is not,
maybe I'm
that,
naive.
that's not the position I'm trying to take. I'm trying to say that as
I'm
a,
saying nobody's going to be displaced. But under that scenario.
well, that would be a decision made by individuals that
so
are
is the
family
one-
members.
So is the
You,
one if Miss Elliott decides to leave her family and go live in the senior housing.
that Miss Elliott,
That's exactly the same situation, but you're saying that Miss Elliott's, the rest of Miss Elliott's family will have a right, an entitlement to stay. That's no different from the husband in the example I've given you, is it?
I think that, I mean, that is the position I'm taking. I think that that position can be softened to say that voucher holders in general that have a voucher at that property, that it would be understood that a voucher holder, if they chose not to separate from their family, could use their voucher at the property. And I think that people should absolutely be able to be given the choice, a person like Miss Elliott, to be able to go to the senior building and live in the senior building if she wants to, or the ability to stay with their family. And I know
It's
that
quite
can,
clear from the second stage order that she has that very choice.
except, but for, one, she's a voucher holder, so the second stage order says she has no right to stay should her rent exceed the
Her
market rate
options
level.
under the second stage order are only to go to the senior building. She has
Exactly.
She has a guaranteed unit in the senior building. She does not have a guaranteed unit under the second stage order as written to go into the mixed-use housing of Building A.
Sure. Yes, I think that's a,
I'm,
But
could you point out to me where you think it says she has a guaranteed right to go into the senior building?
is that me or, I believe,
Well, I'm asking you.
Judge
since
Easterly,
you
if you
agreed
could
to
help me
that.
out,
I'm
you had read it
looking at
earlier. I don't-
I'm looking at page 40 of the second stage order, B subparagraph 2. If an eligible senior lives with a family that includes non-seniors, that senior may elect to continue to reside with their current family members in another multifamily building at their preference. If a senior makes this choice, the project-based Section 8 slot remains with the leaseholder, and the available slot in the senior building will be filled with an eligible senior utilizing a voucher.
I'm sorry, Judge, what paragraph is that again?
That's B sub 2
Okay.
on page 40 of the second stage order.
Do you understand that to mean that that a senior holding a voucher is guaranteed a place in the senior building?
I understand exactly Judge Easterly's point, that it says an eligible senior utilizing a housing choice voucher may make that decision, but I think that then there is a contradiction. One page later,
I wonder how long that guarantee lasts. Suppose the senior building gets filled up.
absolutely. Suppose it does.
I mean.
Yeah, I mean, this
has
is
to
the
interpret
point.
this order reasonably.
Well, my position is that voucher holders, no matter what, should be able to stay at the property because that was the intent and purpose of the first stage order. That's my clear position on this. And I'm more than happy if Mid-City wants to accommodate everyone, that we do that. And that we make that commitment that was clearly made at the first stage order, a written, clear commitment. But this zoning order certainly has to be addressed because there are two issues in this, there are three findings in this order that would say voucher holders can't stay, families can't stay. So those issues have to be addressed. If we're going to say that these findings move to the logical conclusion that this application applies with the intent and purposes of the first stage, which guaranteed the right of return.
Perhaps this is better reflected at page 35, 36, right? where it says, the senior building units will be comprised of permanently affordable units reserved for residents who will be assisted by project-based and/or HCV Section 8 programs, and will be used to house existing Brooklyn Manor residents as demand dictates, with the balance, if any, open to income qualified tenants. Right? And then goes on to say, this means there will be two kinds of Section 8 units in the senior building, project-based Section 8 units and the HCV Section 8 units. If an eligible senior goes, right, the project-based Section 8 slots will only be assigned to the senior building at the election of the leaseholders. If an eligible senior lives with a family that includes non-seniors, that senior may elect to continue to reside with their current family members in another multifamily building at their preference.
Your Honor,
I
I,
understand this to
Yeah.
mean that if you are a senior, whether you have a voucher or you live in a project-based unit now, you can live in the senior building.
Your Honor, that is
then-
absolutely the clear reading of that.
And then if you are a senior with a project-based unit, who resides in a project-based unit, you can opt to live outside of the senior building with your family.
If you're in
But
a
if you are
project-based
a
unit.
voucher holder, you do not have that choice. You can only go, you are only guaranteed housing if you go to the senior unit.
Correct.
Right. But
And
what
the-
I understand Mid-City to say is, we are willing to work this out and make sure that all of these seniors and other voucher holders will be able to use their vouchers at our property.
I would love to work with Mid-City to ensure that that happens. We've asked for that multiple times. That is not something that's
Well,
gone over.
things
our
might
head.
have changed after today.
Yeah. Is there anything else, Your Honor?
I think that's it.
Thank you.
Thank you, counsel.
Yep.
Case is submitted. You need to take a recess. Can you? No, but I don't think so.
You want to do it the old-fashioned way, don't you? Just as long as you
You're
don't,
typing along there.
as long as you don't point it.
And throw it.
Or throw it. We just did this birthday party for my daughter where we had to play these silly games, like get pencils into cups by
Hold on one sec, there's still a bit of commotion in the back there. Okay, thank you. We'll call the case of Miller versus United States, counsel.
Thank you.
And we appreciate the patience counsel have shown in this case and the third case. while we got through
Understand.
the first argument.
Sometimes it's a case of great public importance. Good morning. May it please the court, I'm Richard Stolker for the appellant. I appreciate the court appointing me to represent Mr. Miller in this matter. In our brief, we raised two issues. The first of them has to do with sufficiency of the evidence. I must inform the court that upon rereading the transcript, I believe I may have misconstrued the complainant's testimony. He did not identify the appellant in court, but he did identify appellant from a photo array, and he was fairly firm in his conviction about that. In the circumstances, I believe there probably was enough to go to the jury, and therefore we're going to withdraw the argument as to sufficiency, and I've informed the government of that previously. I'm sorry if I got the court started on that. The second argument that we raised has to do with the partial verdict and the substitution of an alternate. My client was charged with 6 different counts. Conspiracy to commit credit card fraud, robbery, credit card fraud, theft, and assault with significant bodily injury, and finally, conspiracy to commit robbery. What happened, as the court knows, and I've gone over this kind of carefully, is that the court substituted an alternate after a partial verdict was returned by the jury. The government argues that by requesting a partial verdict instruction, the defense waived the claim that we now make on appeal. Obviously, we agree that when the defense requests a certain argument, that they've waived the right to complain about it. We don't disagree with that. Partial verdicts are not prescribed by the rules, and this court has condoned their use. We also don't contend that the substitution of an alternate juror, at least per se, violated my client's rights. So our argument, if I may articulate it a little more concisely, is that under the circumstances that were presented in this case, it was error by the court below to take a partial verdict and then substitute an alternate when the jury had not indicated it was deadlocked on the other 2 counts that it hadn't decided yet.
It's a component of the government's argument, I thought, not just that there might have been some kind of a lack of preservation of this issue by seeking a partial verdict instruction, but also that if this was your client's point, it ought to have been brought to the trial court's attention at the time that there was the process of removing the juror and then replacing with the alternate and instructing the newly constituted jury about what to do. And there was discussion about how to instruct the newly constituted jury, and the trial court said, here's what I plan to do. I'm going to tell the newly constituted jury that it should deliberate about the remaining counts, but that the partial verdicts will stand. And then the trial court turned to the 2 counsel and said, any objection to what I propose to do? And counsel for the government said no, and counsel for the defendant said no. And I think it's a component of the government's argument that if something was going off the rails at that juncture, it was incumbent on the defense attorney to object. And if there wasn't an objection, then our review will be for plain error. What's your response to that line of argument?
As I recall, Your Honor, he did object. Maybe it took him a moment to collect his thoughts, but I believe he did object. He asked for a mistrial.
Well, there comes a later time after the jury has been so instructed, and the newly constituted jury starts deliberating on the remaining counts. Ultimately, a note comes out, and the note does seem to draw into question earlier verdicts, and then there's a colloquy about that, and there's an indication that one of the jurors might not be very happy with the earlier partial verdict. And at that point, there was a request for relief. But the government's argument is, if you think that really the partial verdict shouldn't have been honored and it should have been open for reconsideration as soon as the new jury was reconstituted, then you should have said to the trial court at the time the reconstituted jury started its deliberations. That's not the right way. It's not right that the partial verdict is sacrosanct and final. It should be brought into to the deliberations of the newly constituted jury. And why aren't they right about that?
Well, I don't think they are, because I think that the issue was properly preserved for appeal on the Monday, on the 20th of what was it, November. Let's go back
Well, let me
from,
just ask you though, so when the trial court instructed the newly constituted jury, don't deliberate, and I'm paraphrasing, don't deliberate about the previously returned verdicts, deliberate only on the remaining counts. Do you think that was an erroneous instruction?
I think the error occurred on the Friday, not so much on the Monday, because,
I'm just asking you whether you think that is an erroneous instruction.
well, I think it was a continuation of an error that the judge created on the Friday afternoon, because once the partial verdict was taken, and that's really where the error was in our view, once the partial verdict was taken, it stands. That's the case law in this jurisdiction. I
Well,
think,
was there an objection to taking the partial verdict, if that was the error?
well, that's what I was about to get into, because I just want to briefly review the facts. This is what occurred, and this was late on a Friday afternoon, and as the court is aware, the Superior Court is adamant about matters being concluded by 4:45. So at the end of the day, well, somewhere during the day, a juror sent out a note saying, when are we going to be finished with this, because I have to leave. So the judge says, let's deal with that at the end of the day. So the end of the day comes, and the juror, number, I think, 13, is called to the bench with counsel, and says, what's the problem? And the answer is, I have to leave on Sunday. And there was some discussion about, are you flying, are you driving? Turns out she was driving. And the defense says, well, why don't we see if she can postpone her trip by a day and finish up on Monday? And the judge says, no, we're not going to do that. And then somewhere right in the middle of this, and again, it's the end of the day, the deputy clerk says the jury announced that they've reached a unanimity on some of the counts. So having let juror number 13 retire back to the jury room, everybody's wondering, was this done while she was here at the bench, or was she in the jury room when they reached a verdict? So the jury is brought back in.
Well, on that, there was an inquiry about that, and the determination was it was
There was
made while
inquiry
she was
about
still
that.
part of the jury.
And the judge, at the end of this, says to the attorneys, would you be, or specifically to the defense, would you be satisfied if I voir dire the foreman with respect to whether the verdict was rendered with all 12 of them there? And the defense says, fine. And then apparently, according to the transcript, at that, the judge says, okay, I'll poll them after the verdict. And before there was an opportunity to say verdict, the jury comes back in and the judge takes a partial verdict. And that's where, in our view, the error occurred. Because at that point, the court knew that it had made the decision to substitute an alternate when the jury came back on Monday. And yet, he took a partial verdict. And that, we believe, was incorrect.
And there was no objection to doing that.
There was no opportunity, as I see the transcript, for an objection, because the judge says, I'll poll the jury after I take the verdict, and the jury comes back in. Right
Well,
away, it's the end of the day.
Well, I mean, if the defense attorney had thought that was done and I didn't get a chance to put a word in edgewise, I would think the defense attorney, after it was done, I mean, I think the defense attorney would say, Your Honor, if you can hold on for a moment, I have an objection to make. But even if the defense attorney was unwilling to do that, once it happened, I think the defense attorney would be inclined to say, just to be clear, I object to that. I would have interposed an objection. I wasn't able to interpose an objection. But neither on that day nor the next, the next day when people are discussing any of this, is there any suggestion by the defense attorney that the defense had any problem with what had happened until after the reconstituted jury begins its deliberations and then a note comes out. And even then, the objection isn't, you never should have taken a partial verdict.
Well, I think it would have been clearer if, at that moment, the defense attorney had the wherewithal to say, I've had this, I know the law exactly on this point, and I object to your taking a partial verdict and then reconstituting a different jury. But it doesn't appear that in that brief moment.
Can I ask you, is your theory that the objection, I mean, assume you're right, that the trial court couldn't both take a partial verdict and appoint an alternate and reconstitute the jury. You seem to be suggesting that that would mean that the trial court would have had to refuse to take a partial verdict. Couldn't the trial court instead, assuming you can't do both, couldn't the trial court instead have said, well, let's take the partial verdict. If I can't reconstitute the jury, then we'll go down to 11 for the remaining counts, or we'll declare a mistrial. Whatever happened on the remaining counts will happen on the remaining counts, but I can take the partial verdict.
I agree with that, Your Honor. I think that the judge could have determined either we're going to take a partial verdict and mistry the other counts, or we're going to hold this whole thing over to Monday with a different jury, bring back the alternate, and do what it says in Rule 24C, which is to.
And if the court had done the first, take the partial verdict, declare a mistrial, or go down to 11 on the remaining counts, how would your client be better off than what actually happened, which was taking the partial verdict, have deliberations by a reconstituted jury that ended up in a mistrial?
So that goes to the prejudice. That's what Your Honor is asking
Yes.
about the prejudice. Look, I think there's some real points on that. One of the cases that I know Judge Glickman is familiar with because he wrote the decision was in the Hinton case 10 years ago, Hinton versus United States, and I believe, Your Honor, Judge McLeese, you were on the brief in that case. And this was a case that was in which a juror was permitted to ask, the jurors were permitted to ask questions during the trial, but one of them asked some questions that, while arguably appropriate, the judge was concerned about the jurors' ability to interact with the other jurors. And that juror was dismissed, and the judge put in an alternate, and the court said, well, that wasn't, ultimately, the court said that that wasn't a valid reason to let the juror go. There was a considerable amount of discussion, which I think was interesting, about the history of alternates, and about how a defendant does have the right to object, to complain if the rule is not followed, and how prejudice arises in this case. And a lot of that really isn't this case. But I think there's some interesting dictum in there. The court took note of some of the pitfalls of substituting alternate jurors. Quoting from the case, once the jurors start hearing and considering the evidence, jurors may evaluate it differently, and they may no longer be viewed as fungible merely because they have passed muster in voir dire. And that's, I think, instructive about what happened here. There were at least two counts that were very closely related. There was conspiracy to commit robbery and robbery. And it seems to me that it was error for the judge to say, okay, I'll take a partial verdict on the robbery, but you go back and consider the conspiracy to commit robbery as well as the assault count. This was one continuous, all related event.
Are you making the way you just articulated the error, it had nothing to do with the substitution of an alternate or removal of a juror? Are you saying that you think there's a limitation on the authority of trial courts to take partial verdicts, where the partial verdict is on some counts that are closely related to other counts as to which no partial verdict is being rendered?
And that brings us to the case that I think is the closest. It's not binding on this court. It's the Seventh Circuit case, excuse me, that was decided in 2014, United States versus Moore. I think that's the closest case. It's closer than the other cases that we found. In that case, Mr. Moore was charged with carrying a firearm as a convicted felon. Carrying a firearm in relation to a crime of violence and carjacking. And the jury deliberated, and their deliberations ran into the early evening, and they asked for permission to go home and come in later the next day. And the judge said, no, let's take a partial verdict now. And the court in that case said, among other things, a premature inquiry into whether a jury has reached a verdict as to at least some charges or an unprompted mid-deliberations instruction informing the jury that has the option to return a partial verdict may impermissibly intrude upon the jury's deliberative process. I think that's
Though
appropriate.
neither of those two things happened here. I thought that it was the idea of partial verdict was prompted by a jury note.
But the point of the Moore case, I think, is that where the jury has not said it's deadlocked on some of the charges, which is our case, the jury, the court acts incorrectly if it then takes a partial verdict, especially where the counts are, as they were in Moore and as they are in our case, closely tied together. They all involve really a single chain of incidents.
Is it, I was under the impression that it is not uncommon for juries to return partial verdicts and then continue deliberating. They don't have to be deadlocked on the remaining counts, do they, before the court can take a partial verdict?
Well, I think that Moore and some of the dictum in DC cases that we've cited indicates that although the court can take a partial verdict, and although the court can substitute an alternate when one of the jurors becomes unavailable, the court has to tread very carefully in doing those two things in combination, because you wind up with a circumstance as here, and again, I'm quoting from Moore, jurors may not realize that in delivering a partial verdict, they are foreclosing to themselves any further consideration of the charges included in that verdict.
I'm back to the idea that the thought that you're raising, which is if a jury sends out a note about a partial verdict and they don't indicate they're deadlocked on some counts, but
I'm sorry, they are.
They do not. They send out a note saying we have a partial verdict, and they don't indicate that what their status is on other counts. It's just we're done with a few, so we'll let you know, and we've let you know we have a partial verdict. That a trial judge needs to be careful about accepting such a verdict, and maybe it shouldn't do it, or shouldn't do it if there are relationships possibly between the counts and all. If that's your point, I'm back to the question of whether that was brought to the trial court's attention and in a timely way. And I think you acknowledged that it wasn't, but you took the view that there wasn't really an opportunity to make the objection. And I'm just wondering about that because I'm looking at the transcript where this was going on, and
On the Friday, the 17th, Your Honor?
yeah, it's page 755 of the transcript as it's annotated. I think that's the Friday. And the trial court says, the deputy clerk says they have a partial verdict. The court says, okay. The prosecutor says, so we'll take the partial verdict, and then they'll start deliberating again on the other verdict. Is that how that would work? Trial court says yes. The defense attorney says, and the only question I have, not my objection, is that's not what you should be doing. The only question I have is, do we know about the timing of the verdict, paraphrasing, but is it a verdict that reflects the participation of the juror who's about to be excused, or who'd sort of already been excused, I guess, or not? And so it seemed like if Mr. Oliver, who was the defense attorney, had an objection, it's not like he was foreclosed from making it. There was an opportunity where he weighed in on what should happen, and he expressed a concern that wasn't the one you're identifying.
Well, let me answer it this way, Your Honor. I think for the reasons that I stated, that the objection was preserved, perhaps not as timely and clearly as it might have been. But I would say in the alternative, in the circumstances of this case, where the judge essentially created the problem, knowing that he was going to substitute a juror on Monday and still taking this partial verdict. So our contention would be that even if it wasn't timely objected to, it constitutes plain error in the circumstances of this case. I'd like to reserve a couple of minutes, if I may, for rebuttal.
Let me just be sure I understand your position. Suppose there had not been any issue of reconstituting the jury. Suppose there had just been a note from the jury, we have a partial verdict, would you like to, and we're still deliberating on the other counts, would you like to take it? Is it your view that it would have been error for the judge, that would have been error to take that partial verdict and allow the jury to continue?
The same jury to continue on the
Same
next
jury.
day? There's no problem with that under the case law of this jurisdiction.
Okay, now, if that's not a problem, then given the fact that the reconstituted jury did nothing harmful to your client because they ended up mistrying the remaining counts, I have trouble seeing how that error, even if it was an error to allow the jury to continue with a reconstituted, with a different member.
Well, the
How that
language of Rule
prejudiced
24C, and
your
maybe
client
it's
in
not
any
as
way.
clear.
Excuse me?
I'm sorry?
I'm having trouble seeing how that prejudiced your client in any way. Because there was no consequence, adverse consequence to your
Well,
client.
the consequence is, and the court, I
due
believe
to
in
the error
Hinton's,
of allowing them to continue with a different constitution.
okay,
with a different
because I think this court has recognized that there can be prejudice per se by improperly substituting a juror, improperly doing so.
Well, if the jury, after it had a new member, came back with a guilty verdict on one of the two counts, you could argue, well, there's the prejudice. But since that didn't happen, and if I understand correctly, the government is not seeking to retry your client on the remaining two counts, what's the prejudice?
Because, and I guess I'll answer it this way, I'm paraphrasing more. Jury number two, which is a different jury, by composition, that comes back on Monday, only has before it the fragments that were left over from the partial verdict. If that jury, which was deciding Mr. Miller's fate on Monday, had been able to do what I suggest Rule 24C says they must do, which is to begin their deliberations anew.
But that wouldn't be the case, that would not be the case if the partial verdict were taken and the same jury were allowed to go back.
But that doesn't trigger Rule 24C, because 24C is triggered when there's an alternate. So,
Well, I understand the difference. I'm just trying to grasp what the prejudice is since the reconstituted jury.
well, I mean, I understand that the second jury came up with a not guilty on the remaining charges, but they were supposed to have before them the entire panoply of charges, because it's now
Your
a
point is
different
that the
jury.
All right, but I thought you were saying the error was made, I thought you were saying the error was made on Friday when the judge took the partial verdict. It's that was the premise of my
Well,
question. I was responding to your argument that the error occurred then in taking the partial verdict.
Just to be clear on that, Your Honor, and then I'll sit down. To be clear on that, the error was the judge already knew, even though he hadn't told the jury, he already knew that he was going to substitute and effectively have a new jury on Monday. Knowing that, it was error to take the partial verdict. Thank you.
Good morning. May it please the court. My name is Ethan Carroll, and I represent the United States. Appellant has waived review of the jury's partial verdict, and even if he did not, he cannot establish plain error for his claim that the court should have allowed the reconstituted jury to reopen deliberations as to its already partial verdict in light of this court's holding in Boykins versus United States. Going first to Judge McLeese, your questions about the opportunity for appellant to preserve this claim below. I think you're right to point out the colloquy between the court and the parties on page 755 of the transcript, at which point Mr. Oliver said that the only question he had was about the level of participation in the verdict. And then even after the verdict was taken and the jury was pulled, the court asked the parties whether there were any other issues. And Mr. Oliver, at that point in time as well, indicated that there were none. Coming back the following week on Monday, Your Honor also pointed out, and this is something that the government indicates in its brief in terms of the reasons that we are pressing our waiver argument, and then in the alternative saying that any error would have to be reviewed for plain error, is that when the court previewed to the parties what it would be instructing the jury as to the scope of its continued deliberations, in relevant part that it would only be instructing them to to deliberate on counts 1 and 4, because the earlier counts had already been decided and were final. Neither party raised any objection. And neither party raised the objection that appellant is raising now about saying that the reconstituted jury should have been able to reopen deliberations, even at the point that juror number 6 indicated disagreement with the verdict. At that point, appellant's position was that there needed to be a mistrial, not that the deliberation should have been reopened as to the earlier counts. So at all of those opportunities, appellant had the opportunity below to raise the claim that he's raising now. And it was only after realizing that there was a possibility of deadlock that he raised for the first time belatedly the claim that he makes now, which is that Rule 24C3 demanded that deliberations be allowed to be reopened on the earlier counts. That difference.
He's framed his argument a little bit differently. Its precise details have varied a little bit, but one way he conceptualized that argument today was to focus on the trial court's thinking in deciding to to both take the partial verdict and replace with an alternate.
Yes.
And if I understand that line of thinking, it is, if you look at Rule 24C3's last sentence, what it says is, if you're going to replace a juror with an alternate after deliberations have begun, you need to instruct the jury to begin its deliberations anew. And if you take a partial verdict, you can't do that. So it's not a sensible plan to say, here's step A, I'm going to take a partial verdict, and here's step B, I'm going to replace, or bring in an alternate as a replacement after deliberations have begun, because then you're not complying with what Rule 24C3 requires. That seems like a reasonable argument rooted in the language of Rule 24C3. Do you agree that the trial court shouldn't have proceeded in that way because it's contrary to the language of Rule 24C3? Or do you think what the trial court did actually was a correct interpretation of Rule 24C3?
So I don't agree that that's what the trial court should have done. And I don't agree because of what both parties indicated they wanted the trial court to do.
Leave aside issue preservation. Imagine that that issue had been clearly articulated to the trial judge, so that the defense attorney had said, you know, I understand taking a partial verdict is sometimes a good thing to do. I understand replacing with an alternate is sometimes a good thing to do. But you can't do first take a partial verdict and then, you know, as step 2 of your plan, replace with an alternate, because you're only supposed to replace with an alternate when you can tell the jury, begin your deliberations anew. And once you've taken a partial verdict, whatever they're doing, they're not beginning their deliberations anew. They are, you know, starting new deliberations on a narrower set of charges, or, why would that have been an incorrect objection if you think it would be? Do you think that?
In taking a look at the case law, there isn't anything that says that it would be right or wrong. There's an absence of authority about that. That's why, in part of the government's argument was to look at the text of the statute as well as its history.
You mean the rule?
Sorry, my apologies. Yes, the rule, Rule 24C3, which was adopted in the year 2000 by the DC Council to mirror a change to the federal counterpart. And what it did was give to the trial court the discretion to retain alternates, and nothing in its drafting history, as discussed by the list of cases that the government cited in its brief, indicates that there was any discussion of its interaction with I guess, the Rule 31, which discusses partial verdicts. It just isn't something that has come up.
But just looking at the language, just as a matter of plain language, is what the trial court instructed the jury to do in this case, instructing the jury to begin its deliberations anew?
Sure. So when I was thinking about that, I think that the text could be read one of two ways. And there is some ambiguity in what deliberations would mean. If the line of cases, beginning with Dakins and Boykins, and there are other cases I can address in a minute, mean what they say, which is that partial verdict, once rendered as final, then there aren't continued deliberations on those counts. Deliberations began anew, just like they did in this case, on the remaining counts. And Judge Dason instructed the jury, the reconstituted jury, to reopen deliberations, just like Rule 24C3 said that she should. So I think that.
They're actually, I wasn't able to find federal authority, but there is some state authority on this, and there are some state courts that don't favor replacing with alternates after partial verdicts because they think that it is hard for the new juror to come in. And it's hard enough if everybody's been arguing about things for a while, no verdicts have been returned. And then somebody leaves and a new person comes in and the jury is told, well, pretend none of that happened, start all over again. That's hard enough, but we, courts have determined that on balance it's worth doing. But at least one court took the view that that's not really that feasible in a setting where it's not just that people argued for a while and returned no verdicts, but in fact, they got to the point of returning verdicts. And then you add in a new person and say, start anew with what's left, that is not so feasible. So again, to begin deliberations anew, I mean, you're reading it, you're saying it's ambiguous because you could read in a qualifier anew with respect to whatever counts haven't been decided one way or another. But the qualifier is not there, and I would have thought that the more natural reading of the language in isolation would be anew means from the beginning rather than from, a new beginning that is not the very beginning but is, created by a partial verdict.
Yeah, and I guess my response is just, I was responding to your question on these facts as we have them and ignoring the plein air component of this. So, I was just trying to respond to your question.
No, and I'm just trying to assess your response and its pros and cons, and I'm suggesting that one could take the view that the plain language of the rule suggests that what happened here isn't what should happen. And your suggestion is, well, you could read in kind of an implicit suggestion that it means begin deliberations anew with respect to what is remaining to be done. And that's, I agree that is a conceivable reading too, but I was just exploring the pros and cons of it.
Yes, and then in response to there was only one case that I could find that was somewhat similar factually, and because it was based in the California state constitution, I didn't raise it in my briefs. And so if that's the one that Your Honor is referring to, it just dealt with the California state constitution rather than anything that applied in DC.
When do you think, to preserve his objection properly, when do you think that the defendant should have lodged an objection to the procedure that was followed?
So he should have objected before the court took the partial. Well, actually, I guess, sorry, to adequately respond, it probably depends in part on the nature of the objection, because I think, as Judge McLeese may have pointed out, the argument's shifting a little bit in terms of whether it's, an objection to taking a partial verdict when, in the judge's mind, they might be replacing a juror, or whether instead it's the instruction to the jury about how they're going to deliberate going forward. If it's the former, I think that that counsel would have needed to object before the partial verdict was taken. And if it's the latter, then counsel would have needed to object on Monday morning at the time that the court asked for objections as to the proposed procedure going forward.
Well, that's what I'm wondering about. I'm not sure that, I mean, let's go through that again.
Sure.
Say again, if the objection is to allowing a or to limiting the reconstituted jury to only the counts that are left after the partial verdict is taken. What I'm wondering about is whether the objection has to be made, whether there has to be an objection to taking the partial verdict. Because on the theory that the defendant shouldn't be allowed to know what the verdict is going to be, that it's going to be adverse.
Yes, I think Your Honor's right that in either.
But I'm not sure that's right. That's why I want you to go through this carefully with me when you think, depending on what the objection is, the instruction, the objection, it should be taken or is waived.
Yeah, I think
or at the very least forfeited.
In either circumstance, it would need to be made before the partial verdict was taken. In light of
articulate why.
In light of Wake.
Articulate the reason why, for example, it was not too late for, the judge could have, when appellant finally did, when counsel finally did object and asked for a mistrial, the judge could have said, well, you know what, you're right, so I'm gonna re-instruct this jury to go back to square one on all the counts. That seems like it's too late, but let's talk about why it's too late and when the right time to object would have been.
Sure.
It's not too late. The judge could have arguably cured whatever problem there was by telling the jury, listen, I made a mistake. I want you to go. I want you to deliberate again. I want you to continue deliberating, but now I'm deliberating on all the counts. And I'm going to also vacate the partial verdict that was taken.
So that would have been error in light of Boykins, a 1997 decision of this court, where there was a similar factual scenario where the still deliberating jury indicated that they no longer agreed with their earlier returned verdict. And this court held that once final and confirmed by means of a poll, that a verdict is immutable. And so that would have been error under
That
Boykins.
supports the notion that the time to object has got to be before the partial verdict.
Yes, Your Honor.
Yeah.
And I think the other thing to point out in relation to counsel's argument about United States versus Moore is that there is contrary authority in the DC Circuit. United States versus Dakins, which was adopted by this court in United States, in Boykins v. United States. Dakins is a 1989 DC Circuit opinion, which indicated, I'll quote the exact language, "We are aware of no precedent requiring a special finality instruction." There was a similar claim that by accepting a partial verdict before while deliberations were still ongoing and not instructing the jury as to the import of the
Which
partial
case
verdict.
is that, the DC Circuit?
It's United States versus Dakins. It's cited in the government's brief. Probably pretty close.
Dakins, I'm sorry.
Yes.
Yep.
Um, So there was a similar claim that the court should have instructed the jury as to the import of its partial verdict. And the DC Circuit rejected that contention, and it's a case that this court cited with approval in Boykins, the case that I've earlier cited to Your Honor. If there are no further questions, I would ask that the judgment be affirmed. Thank you.
Thank you. Mr. Stover?
Thank you. I'll try not to restate what I said in my argument in chief, but I appreciate a couple of minutes. Starting with the last, Dakins, which is at 872 Federal 2nd 1061. I don't think takes anything away from Moore. And I think Moore is important because it is a federal case. It's a U.S. Court of Appeals for the Seventh Circuit case, and I think it's the closest that we have. And this court has frequently given precedental value to federal cases where we don't have something in our own jurisdiction that resolves that. I did want to,
Do you think it governs in a plain error context?
does Moore, I'm sorry?
Do you think it governs here, given that we're in a plain error context? Plain error standard of review?
Okay, first of all,
Normally, we say for plain error, there has to be a,
we don't agree that we're in a plain error context, but
Ah.
even if we were, I think that Moore still is the closest thing we've got. I think that in response, Judge Glickman, to what, to your colloquy with the government, I think we're in agreement that the essential error in this case happened on the Friday afternoon at the end of the day. Because by Monday, the partial verdict had been taken, and the law is pretty clear in this jurisdiction that a partial verdict, when it's taken in open court, that's it. It doesn't really get upset, so I think it would have been too late.
well, then I don't understand why you say that you don't think we're in a plain error context.
I don't think there was any opportunity. As I read the transcript, the judge announced, it looks like seconds before the jury came in, that he was going to take a partial verdict.
Well, the defense had asked for it.
The defense had asked for it, but I think the intention is when, it's always a little bit dangerous to take a partial verdict, but it's permitted. when you have an alternate, that's fraught with danger. The combination in a case like this is highly prejudicial because the second jury, for all the reasons I stated, I don't want to go and restate what I already said. But in this case, it was appropriate, and I think Judge McLeese indicated, probably more articulated better than I did, that it's fraught with danger when there's unresolved issues and a partial verdict is taken, and then a different jury comes in the following day to hear the rest. I think it was a mistake on the trial court to set this up for the disaster that happened. And we would respectfully suggest that this court reverse my client's convictions and set them aside. And if the court has no other questions, thank you.
Thank you. Counsel, thank you. Case is submitted. Call the third case on the calendar, Mallory versus Bombardier Transportation. I'll begin by expressing my appreciation to counsel for your patience here. That was an unusually long first argument, and we appreciate your patience. Any counsel?
Good afternoon. May it please the court, John Iannone representing the appellant, Thomas Mallory. The trial court or the superior court had to decide whether there was any material issue of fact to be determined by a fact finder. Our position is that the superior court judge considered only some of the evidence to the exclusion of other facts and failed to address the totality of the facts that were in the record to be considered. In essence, there was a decision to weigh certain facts as dispositive without considering or even addressing the other facts that should have been taken into consideration in the finding. For example, once the judge determined that Mr. Maddox states in his deposition that he did not see plaintiff fall and that plaintiff cannot recall how he fell, then the decision was rendered that therefore no other factors or facts were addressed, and that necessarily the decision at that point with that line of logic is that that there was insufficient evidence and that it's a mere allegation without any evidentiary support.
Well, our review of the trial court summary judgment ruling is de novo. So whether the trial court mentioned facts that you think the trial court ought to have mentioned or not may not be that critical. What is critical, because we'll decide it de novo, you tell us the facts that you think ought to have led on our de novo review, a court to correctly conclude that there was a jury question. So again, in some areas where the trial court's reason, like it's a discretionary determination, the trial court's exact reasoning may be very critical. In this area, it's less so. And so what are the facts that you think, I mean, I think you'll acknowledge that it is it's somewhat unhelpful to your case, proving your case, that your client doesn't recall exactly what happened and that the other principal eyewitness didn't see it exactly happen but saw the aftermath. So the question is, what other circumstances can you point to that, taken together with that information with its limits, means that there's a jury question? So what do you think the trial court ought to have included but did not, that gets you over the summary judgment threshold?
And that is the point, that there are other factors. Mr. Maddox doesn't just, his only testimony is not that he didn't see Mr. Mallory fall. It is that he came upon the scene immediately after the fall. He saw where he fell. Mr. Maddox.
I'm a little unsure about that. I thought that there was some uncertainty about exactly where the fall was, because by the time Mr. Maddox happened by, either your client had himself moved or someone had moved your client a little bit away from your client's original location? Is that not correct, or?
Well, Mr. Mallory was moved by EMTs at some point in time. Mr. Maddox came upon the scene, saw him directly in front of the exit of the train because he was right there after, he says, immediately upon the fall, I came up and saw Mr. Mallory in front of the door.
So it's a little hard. I have to go back and look and see if the word immediately was used. If you don't see something happen, what you see is immediately after what you didn't see is a little tricky. How would he have known he was immediately after the fall he didn't see? Or how much time passed between the fall and his arrival?
Well, everyone was disembarking and he came, I should, immediately is probably not completely accurate in the sense that you're saying, but came up shortly after the fall. In other words, he didn't see the fall, he came up shortly after the fall, saw Mr. Mallory in front of the door where he says he fell and where he was exiting, and so combining those facts together, he had not been moved by that time. Mr. Maddox, interestingly enough, is the director of construction of OSHA by happenstance, and given that background, he indicated that he observed the area where Mr. Mallory fell, that the platform itself was comprised of concrete and pavement and was somewhat bumpy, and he observed and was able to mentally measure the gap distance between 20 and 22 inches. Those are very salient facts as to what happened, because couple that with Mr. Mallory, who although says he doesn't know specifically how he fell, what is extremely important is what he does say he did, which is that he very safely descended the steps of the train car itself, the MARC train itself.
So is very safely your description or his terminology?
Well, it's my characterization because he indicates that he said carefully, descended the steps, holding onto the handrail, looking at the steps as he was going down, and the next thing was the gap, is what I will call it. And the next thing he knows is he puts his foot on the platform and then he's down on the ground. Coupling all those facts together, just from factual testimony, that's very salient facts. The case law that the defense rests on in terms of Mixon and Twyman, Mixon is a case where in the record there were no facts whatsoever. So that's simply a mere allegation case where
You'll pardon me for quibbling, but that can't be right. I mean, then we don't even know, like there was a human involved or something. So you must mean something a little narrower about there was no fact relating to exactly how a fall occurred. I mean,
well, the court indicates that there was absolutely no evidence as a substance or that was indicated. Basically, the plaintiff said something had to have happened. He then testifies at some point that it must have been a substance, grease, but the court rests that decision, as far as I can tell, on the fact that there was no evidence. That it was said, but there was no evidence.
and how would you compare it to Twyman? Because in Twyman, there was testimony that the stairs at issue had defective circumstances. And so in that sense, it's closer to this case than the Mixon case that you've been discussing. So how would you distinguish this case from Twyman?
It is, and I believe the biggest issue that I want to discuss today that separates this case from the other cases is the fact that in our case, in the Mallory case, Mr. Mallory is able to talk about what he did and exclude any other cause of what could have happened.
Did his deposition exclude other causes? Was he asked, did you lose your balance? No, I did not. I don't know what happened, but I didn't do that. Or did you catch your foot on something? I don't know what happened, but I know I didn't do that. Or are you just so I'm wondering, did his deposition testimony expressly include other causes?
It was
Exclude other causes?
It was explored because his statement was, I considered it a safe disembarkment in terms of what he did. And so, because the questions were, and what prompted him to testify, what he did was holding on to the handrail and descending the steps and looking at the steps as he went down, and the next thing was as a result of those questions.
But, well, right, but you were saying he excluded other causes, and I guess my question is, did he expressly exclude other causes, or are you inferring that there weren't other
Well,
causes?
the record is certainly devoid of any other facts whatsoever and I might add that the circumstances themselves is, the only thing between his step off of the last step of the train and the platform is a gap in the platform. And such that, coupled with his statement of his safe disembarkment from the train, is that there is no evidence of anything else.
And how is that different from Twyman?
Twyman was unable to exclude any other facts, such as tripping on her own accord.
Well, your client didn't exclude tripping, just it wasn't tripping up to the point of the walking down the stairs, right?
He didn't trip on the steps, correct, and fall off the steps onto the platform. He said he safely disembarked the train on the steps, and his next step was onto the platform itself.
What does he say? He's walking down the steps, and he got to the bottom of the steps, and then what does he say he does remember happening?
That his left foot was the first one to go down, and that once he landed on the platform, he was down on the ground. The next thing he knew, he was down on the ground. That's his direct testimony.
Does he exclude having fainted during the process, for example, of walking down the steps?
He does not testify that he fainted or that he didn't faint. If in terms of his
I mean, it's
deposition.
sort of puzzling. If he was conscious, it'd be one thing if he wasn't, you could understand him not knowing what happened if he was conscious during the entire time.
That is how he testified all the way
What I
through.
wonder is whether the explanation is that he fainted and, for whatever reason.
all
Not
through
that
hi-
there's any affirmative evidence that he fainted.
Right, all through his testimony and medical records and in terms of what he reported to the medical providers and everything, there was nothing that indicated any other cause, nor was there any medical evidence of any other cause.
I take it there's no photograph in the record showing the condition of the platform
There is.
of the,
There is of showing the asphalt and the concrete and other areas where they have the safety area yellow with the raised bumps for
does that
safety.
show the particular spot where he fell?
Yes.
Well,
Yeah,
is
I
that
thought that was-
based on Mr. Maddox's deposition testimony, or how do you link that area of the platform to where your client fell?
That is Mr. Maddox's testimony as to
Okay,
where he's.
because I'm going back to the transcript, and, Mr. Maddox is asked in, this is the appendix 293 and 294, when did you hear Mr. Mallory had an accident? I didn't hear it. When I got off the train, I started walking towards Union Station. I went up, I believe, 2 cars when I could see that a fellow passenger was down on the ground. He's seated on the pavement, that's at the bottom of the page, sort of propped up with a conductor. And then on the next page, approximately how close would you say he was from the steps of the train when he was on the ground? 2 to 3 feet. So the passengers could disembark the train as he was sitting? Yeah, he had kind of moved off to the side of the doors. So, he doesn't know if he was moved because he wasn't there, but he's not right in front of an exit from the train car. He's somewhere else.
Well, the 2 to 3 feet, my understanding was that the 2 to 3 feet was up farther, not up against the direct area of the step at that point, but in the
My
area.
only point is Mr. Maddox has no idea where Mr. Mallory got off the train, and when he comes upon him after walking 2 train lengths to go into Union Station, he sees him at a certain location which apparently is not where he fell, because it's not right outside of any train car, it's to the side of a door, and that might be the door or might not. Is there any testimony that that's the door?
When you combine the testimony of Mr. Mallory as to where he fell and where Mr. Maddox came up to him, that matches.
So if I look at Mr. Mallory's deposition, I'll find testimony that says that door that was I was 2 to 3 feet away, sitting next to the conductor, is the door that I exited?
He indicates that he descends that car that you just mentioned, that area of the car, and descends and falls on the platform in front of the door.
And am I right in recalling that the photograph that's in the record was not taken immediately by Mr. Maddox, but instead that at Mr. Mallory's request at some point later, Mr. Maddox took a photo of where he believed he had seen Mr. Mallory? Am I right in recalling that?
That's correct.
There's
I
some
believe it was
dispute
the
about-
next day. It was not the day of. I believe he went back the next day he testified to, and took pictures of the platform in the area where he had seen Mr. Mallory.
And in your view, does your client's deposition testimony exclude the possibility that as he was taking the last step, he lost his balance, not due to the condition of the pavement, which he can't testify to, but just he didn't have his weight aligned right, or his shoe was off a little askew, and so he fell over? Does it exclude those things, or, in your view?
I believe that certainly the jury can make a proper inference based on the gap and the condition of the platform, that was a substantial factor in what caused his fall. We're talking about potentially concurring negligence here, or conditions that contributed to it. But yes, his testimony is very clear in terms of that it was a safe disembarkment. I mean, he makes that statement.
Well, I mean, obviously, there came a time when it wasn't a safe disembarkment because he fell and was badly injured. So the issue is just at what point, for what reason, did what seemed to be a safe disembarkment become unsafe?
Well, his inability to say that anything in particular happened that was specific to him, which is what he was testifying to, that it wasn't him.
Well,
In
I mean,
terms of-
again, he didn't, unless that you're referring to a part of the deposition testimony I didn't focus on, he didn't expressly say, did he? It was nothing internal to me. I don't know what caused it, but one thing I do know is it wasn't something that was going on inside my body. It was some external force. Nobody asked him questions like that. Or am I missing some part of the transcript?
No, not in those words, but when he was asked about how he disembarked, he is going through the steps, and all of the steps that he testifies to do not involve anything that he did or that he can attribute to himself.
Do we
Now,
know-
that's the
do-
credibility issue ultimately, but
Do we know, does his testimony exclude the possibility that right as he was putting his foot down, a bypasser bumped into him?
there's no evidence to that, nor does he testify that occurred. Once
Understood.
he's
But
down-
my
once
question is
he's-
just, does his testimony indicate that didn't occur? Or do we know whether that did or didn't occur?
There's an absence of evidence to
One way or
that.
the other.
One
So
way
we
or
don't
the
know
other.
it didn't, we don't know it did. There's just no evidence as to whether it did or did not.
Not all of the possibilities I can't say were explored. But in terms of the overall conduct of Mr. Mallory and what he did, when he was asked about his actions, was all incrementally, all the way through, going down the steps, holding on to the rail, looking at the steps, going all the way down, and stepping onto the platform, and then on the ground.
Right, is this fair or not fair, do you think, that your client's direct gist of your client's deposition testimony is nothing that I was aware of that was going on to the moment I put my foot onto started putting my foot onto the ground caused the fall. Further than that, I have no idea what caused the fall. Is that a fair summary of
I
his
think that's a
testimony?
fair summary all the way through. He puts his foot down on the ground, and then he's on the ground.
I just want to go back, I'm sorry, I was looking at Mr. Mallory's testimony about where he was on the platform. And he's asked, are you saying the platform that's depicted on the last page of Exhibit 2 is similar or looks like the spot on the platform where you fell? Yes. Where were you? Can you tell from, or actually, can you tell me where you were actually sitting after you fell with respect to in relation to this picture? Do you want him to circle it? Is it, I mean, I don't know how he's going to tell you. I don't know. Does this picture show any part? Does this picture show the part of the platform where you came to rest, where you sat after you fell? You asked if I saw something familiar. Uh-huh. I told you what I saw was familiar. That's all I can remember. Okay, are you identifying this spot on the platform as the spot where you actually fell on the October 9th? I don't know.
That certainly is the testimony, but his affirmative testimony in terms of what he did coming down the steps was coming down the steps, stepping, the next step was the platform, and that's where he fell. That's not to say that that's not accurate testimony or that I'm disputing that. His other testimony is, in terms of his actions, were coming down that flight of steps and stepping off onto the platform as the next step. If I may reserve a few minutes in rebuttal,
Okay, yes.
if the court so desires.
I was thinking about asking a question, but I think we'll let you sit down and we'll give you a few minutes here.
Thank you.
Counsel.
Good afternoon. My name is Janine Johnson. I represent Maryland Transit Administration. I'm one of the appellees here, and I'll be making the arguments on behalf of all three appellees, Bombardier, as well as
I
Amtrak.
apologize. You are Christina?
No, sir.
No.
Janine Johnson.
You are Janine Johnson.
Yes, sir. May it please the court, I would proffer to the court that the evidence in this case shows that there is no genuine dispute as to material fact. Even assuming that all the facts that Mr. Mallory alleges are true, there is no causal connection between what he contends, between his fall and any causal act by the defendants, or excuse me, the appellants. First off, Your Honor, I think Your Honors all pointed to the testimony of Mr. Mallory, and the testimony of Mr. Mallory is very clear, that he stepped off the train and that he felt pain in his foot, and the next thing he knew, he was on the ground. He testified very clearly that he does not remember the incident with a lot of clarity, and that he has no idea what caused him to fall. He also testified, which Judge Easterly just pointed out, that he could not identify a particular spot on the platform as to where he fell. And contrary to what counsel has told you here today, he was in fact moved after he fell. His testimony, which I would direct your honors to at AA 246 and 293, indicates that he was moved after he fell. And that was before the paramedics came and before before Mr. Maddox came onto the scene. He was moved. So there is no testimony as to the direct area as to where he fell.
How do we know he was moved before Mr. Maddox came on the scene?
The testimony and I will direct you again to 246. His testimony is that he was moved after he fell. He did not know who moved him.
How do we know he was moved before Mr. Maddox came upon him?
Let's see. I believe the testimony is, and I'm trying to locate it here. Okay, the question at the bottom of page 86 is, which is also AA 246, do you move from the spot where you actually fell or further towards the middle of the platform? No, I did not move myself. Okay, did someone move you? And I am not sure who it was. I don't know if it was the police or if it was MTA, but it was somebody that was authority. So after you first fell, did someone move you, I guess, out from directly in front of the train? Yes, and that was before EMS came to take you on the gurney. I'm not sure who it was, but when you fell, did you fall directly in front of the doorway? Yes, and do you recall if passengers stepped over you? I don't recall, and do you recall how many people assisted in moving you? He did not recall. So again, that testimony was that he was moved immediately after the fall, and
I'm sorry,
the testimony of Mr.
You use the word immediately. Is that his testimony or your inference?
That is my inference, Your Honor, but he does say that he was moved after the fall, And he does testify that that occurred, as you can see here, after he fell. It was before, he says it was someone in authority, but it was before the EMT arrived.
I thought he said he wasn't sure whether it was before EMT arrived. Can you point me back to the part where you think it's clear that this happened before EMTs arrived?
Yes. So here it says, did you move from the spot where you actually fell to further towards the middle? He says, no, I did not move
Remind
myself.
me where you are now.
This is
I
at
know
the
you're on
top of,
246, but which page?
at the top of 87.
Right, okay.
87. I did not move myself. Okay, did someone move you? And I am not sure who it was. I don't know if it was the police or if it was EMS, but it was someone that was in authority. So after you first fell, did someone move you? And I guess from directly in front of the train, the answer is yes.
It's clear that nobody moved him before he fell. So he definitely was moved after he fell, but I thought you had indicated that he was moved before, you thought his testimony indicated that he was moved before EMS arrived. And that's the next question that was asked, and he says, I'm not sure who it was.
Your Honor, my understanding of this testimony is that it says, after you first fell, did you move, I guess, from in front of the door? And he says, yes. So that would have been after his fall, and that would have been, I understand his testimony is that he wasn't sure if it was EMS, but it was before the EMS arrived.
But then at the bottom of the page, he's asked, were you in fact moved from the spot where you, yes, originally fell to some other spot on the platform? Yes, okay, and that was before the police showed up and the EMT showed up. Nobody touched me before the police showed up, so the police took control of the area.
And just to follow up on that, he then, it's clear he's using the word police, but he's not sure, he means somebody in authority, but somebody asks, is it Amtrak police or Metropolitan Police? He says, I don't know. But again, it seemed to me a little less clear than you're suggesting from at least this passage in the transcript that, I mean, it is clear that he was moved.
Yes, Your Honor.
But what seemed less clear was the timing of that movement relative to the arrival of EMT, which is relevant because by the time, according to Mr. Maddox's account, Mr. Maddox doesn't see Mr. Mallory until EMTs are there. But I just wasn't sure you could line all those three things up because it wasn't clear to me exactly when EMT arrived relative to the movement.
Your Honor, I believe from the testimony that you would be able to line them up. Again, in this testimony passage here, he says that he fell in front of the door. And Mr. Maddox's testimony is that when he saw him and he came upon him, he was not in front of the door. So I think you can infer from that that he had been moved.
Did he say he was not in front of the door or he was 2 or 3 feet away?
He said 2 or 3 feet away.
Right, and there is a question of whether that means perpendicular to the train and therefore you're still in front of the door but 2 to 3 feet away from it in one sense of in front of the door, or whether it means some other angle of movement, and that would be relevant to trying to triangulate exactly what the condition of the track was at the place where Mr. Mallory's foot came into contact with, I don't mean the track, I mean the platform.
I agree, Your Honor. However, I think based upon the evidence that we have before us, whether he was moved or not moved, the evidence is clear that he has no idea what caused him to fall. And I would proffer to the court that just change the names of the case. In this case is the Twyman case. In the Twyman case, the plaintiff testified that she placed her foot on the step and that after that she fell. In this case, Mr. Mallory testified he placed his foot on the platform and he fell. The facts of this case are directly in line with the Twyman case. In that case, again, there was an expert in which the plaintiff tried to use that expert to proffer as causation for the reason of the fall. And again, the court in that case found that that there was no evidence that the defective step was the cause of her fall. And I think here the same thing applies. There is no evidence whatsoever as to what caused Mr. Mallory to fall. This case is directly on point with the Twyman case. And in addition to that, Your Honor, I would...
If we posit, which I realize is disputed, but if we posit that there was sufficient evidence to show, to get to the jury to show that there was a dangerous condition at the location where he fell, perhaps due to the confluence of the height of the final step above the platform and the condition condition of the platform, if we posit that, what's wrong with the following argument? The jury could say to itself, you know, he doesn't know how he fell, but there's no obvious reason why he fell. There's no evidence that explains it. There's no evidence that he was pushed or that he fainted or that he lost his bearings for some reason. And we have a dangerous condition here. More likely than not, his foot, ankle twisted when it came down, you know, having to make a larger than safe step on a platform that was uneven, dangerously so, and that's what happened. Why is it the jury couldn't draw that inference when it's, you know, as being more likely than not the case?
Your Honor, before
In the
we,
absence of any evidence, any other possible explanation, not possible, in the absence of any other explanation for what happened.
before we even get to those things, Your Honor,
If he
I
had
think,
fainted, for example, he would say, well, I fainted. If he had been pushed, he would know it. He'd say, well, I was pushed. Those things didn't happen. I can't tell you what happened. Well, what's wrong with the jury saying, we think we can infer more likely than not that it was his coming into contact with this dangerous condition? Now, I understand there's a dispute about the dangerous condition.
absolutely, Your Honor, and I think without,
So I'm putting that aside for a moment.
but I think that that's important, Your Honor, for Your Honors to consider that there is no evidence here that the height of the step was dangerous. There's absolutely no evidence that step was unreasonable or dangerous in any way.
Well, no
Mr.
evidence
Ma-
is a pretty categorical way of describing things. I mean,
I'm sorry?
no evidence is a pretty categorical way of putting it. One could debate whether it's adequate or not, for sure, but if somebody is trying to figure out, well, is a 20-some-odd inch gap, is that safe or not safe? If somebody said, well, okay, I don't know, you know, here's some information that's potentially relevant to that. With respect to houses in the building codes, you know, stairs are supposed to be 7 inches. That seems to me some evidence. I don't know that it's enough, but I don't know that I would go all the way to saying there's no evidence.
Well, Your Honor, there's no evidence by any expert who's indicated that you would even apply the building code to a train. There is no indication. Again, Mr. Mallory testified that he had been riding trains for 17 or 18 years. There's no indication that this gap was any different than the gap that he normally had transgressed and had done hundreds of times. And also his testimony was that he had been to Union Station and this particular station platform many, many times. There's no evidence whatsoever that there was any difference in any other time that he had transgressed the gap and or the platform. There's also indication that there was a sign over top of the exit that indicated that you should mind the gap. Mr. Mallory
That
was,
suggests that the gap is dangerous.
I'm sorry?
That suggests that the gap is dangerous.
No, it suggests that you should be aware that there is a gap and you should take note of that
Mind it.
and mind it.
Why should you mind it? Because it poses a danger.
I disagree with that. I think that
We don't have,
the
for example,
warning.
we don't have signs at the doorstep here, mind the doorstep. It's not dangerous.
That doesn't necessarily mean that you shouldn't be mindful of walking down steps.
Well, you should be
And you
mindful
should
of
be
that.
mindful when you're walking down steps because there are steps there that you have to walk down and there's a gap
I mean,
between
it
the
strikes
train.
me that I'm not even convinced that as far as the step is concerned, you need an expert because I think it's common sense that if people are, particularly when lots of people are leaving a train at once, it sort of seems like common sense that if the gap is too great, then that's going to be a dangerous condition. If the
But
gap
what's
is-
too great, Your
Well,
Honor?
if it's more than a normal step, and people know what's too great. Suppose it had been 4 feet. Would you say, oh, I need an expert to say that a gap of 4 feet is dangerous?
Absolutely. If there are other
Those were
train,
6
if there are
feet.
other railroad
I mean,
companies,
if at some point, you don't need an expert for this kind of common sense judgment. That's my reaction anyway.
at some
But
point,
I'm getting away from that because I'm saying, assume the expert's testimony was valid. I just want to focus on the causation
yes.
issue. The judge did not decide any other issue, right?
I'm
The
sorry. I
trial
didn't-
judge did not decide the other grounds for summary, this case on the other grounds for summary judgment.
It was primarily based on causation.
So I want to assume that everything else, assume for the sake of argument that everything else is made. In other words, that there was sufficient evidence to show a dangerous condition, a breach of the duty and so forth. I just wonder whether a jury could, what's wrong with a jury saying, well, you know, it's like, what else could it have been? It's hard to see what it could have, how it could have been anything but the confluence of this dangerous condition. And while he can't say it, we can say more likely than not. Because isn't it a coincidence that that in this dangerous spot, he fell just as one imagined he could? You know, the foreseeable danger is the one that occurred.
I
Well,
think-
we can infer that it's more likely than not that that's the cause.
Your Honor, it's
What's wrong with
exactly
that?
what the court said, which is that it would lead the jury to impermissibly assume what could have caused it. It's the same as in the Twyman case. There was no evidence upon which the jury could reasonably find in favor of the plaintiff in that case. The same is here. There are any number of causes that could have caused Mr. Mallory to fall. He was carrying a backpack. Perhaps his backpack started to fall off and he lost his balance. Perhaps, you're right, there were a number of people that were
Well,
exiting.
suppose he had said, I don't remember my backpack falling off. I don't remember myself losing my balance.
But that's not the testimony that we have here, Your Honor. The testimony that we have here is that
You're the
Mr.
movement.
Mallory
You're the
placed
movement,
his,
so- I mean, you moved for summary judgment, so you've got the burden of showing that there's no genuine dispute. Does that mean you've got the burden of showing that there was no other possible cause?
Your Honor, we believe that our burden is that we have to prove that there is no genuine dispute as to any material fact. And even assuming the facts as Mr. Mallory alleged them, which is that there was a gap that was unreasonable, that the platform was bumpy and uneven, even given those facts, there is no evidence here and no testimony by him or Mr. Maddox that, that those conditions caused him to fall. As the court said, there were any number of reasons in which we proffered to the court, any number of other reasons why Mr. Mallory could have fallen. And based upon the case law, specifically Twyman, which is directly on point in this case, there is not sufficient evidence for a trier of fact or a jury to find in favor of Mr. Mallory. That anything that the defendants did was negligent. And that's, Your Honor, the basis of our argument. And again, I would also proffer to the court, based upon some questions that you asked the other counsel, as the difference here. Your Honors referred to pictures of the conditions of the platform. And I would tell Your Honor that if you review the testimony of Mr. Maddox will tell you that he did not take those photographs. He said he did take photographs, but the photographs that he took were months later, in which were taken months later after the incident. He also testified that the photos that were, and that's on, that's part of the record AA 305 and 306, that the photos that were shown to him and that were included in the record were not the photos that he took. And again, even the photos that he took were taken months later. So there's no evidence that the photographs that are depicted in that area are, is the exact area where Mr. Mallory alleges to have fallen. Also, and I know, Your Honor, again, does not want to focus on the causation issue, but I would again proffer to the court that there is no evidence here that the gap was unreasonable or that the platform caused his fall. As he said, that he placed his foot on the platform. There's no testimony that the area that he placed his foot was in fact bumpy or uneven. That is assuming a large area which Mr. Maddox came upon. It doesn't say specifically that the area that he placed his foot was bumpy or uneven. And I think that that would be a huge speculation for any juror to have to make to find that that was the cause of his fall. Again, Your Honor, and I would also point out, to Your Honors, that a simple breach without having some causal connection to the injury does not necessarily produce legal responsibility in this case. And I think the courts have been clear that the simple happening of an accident doesn't necessarily convey negligence, and I think that's what we have here. There's a testimony by Mr. Mallory that he fell and that he was injured, but there is no testimony as to what caused that injury, and I think that any jury making such a finding as to causation would be based purely upon speculation. And for those reasons, Your Honor, we would ask you to uphold the trial court's finding. And also, I know Your Honors review this de novo and find that summary judgment was appropriate.
Thank you.
Thank you.
Mr. Iannone?
Thank you, Your Honors. The basic facts, and going back to one of your first questions, and I don't know if I got all the facts out but was in terms of what the facts are that were presented that are in dispute. Plaintiff descended the stairs of the train where there was no mitigation of a 20 to 22 inch gap. He testified, quote, "I came down from the steps as I normally would. It's just that as soon as I stepped off the train, I felt the pain in my left foot, and next thing I know, I'm on the ground. I was thinking it was a safe disembarkment. I was prepared to get off the train. He was holding on to the handrail while descending the stairs. His left foot was the first off the train, and that his right foot followed. Plaintiff fell directly in front of the train's doorway. At approximately the same time, that's my characterization, but shortly after that fall, Mr. Maddox was exiting an adjacent train car and saw where Mr. Mallory had fallen and took notice of the surrounding area.
Am I right that it's actually not an adjacent train car? I thought it was a couple down.
Well,
Not immediately
I guess,
adjacent.
yeah, not immediately
But-
adjacent, right.
If I understood correctly, and I may not have, Ms. Johnson said that the photo that we were talking about earlier was not the one that Mr. Mallory took?
Maybe the one in the deposition, I was cluing into that too, but maybe the one at the deposition where he was asked to identify, but Mr. Maddox did take photos and of the area where he saw Mr. Mallory fall. So there are pictures.
And that photo is in the record and identified?
That I don't know. Yeah, unfortunately, I don't recall what was attached to the deposition. Not having been the person who took the deposition, I don't have the firsthand knowledge of or defended it.
See, that may well be significant, because we don't really have, if we don't have clear evidence in the record as to the condition of the ground onto which Mr. Maddox, Mr. Mallory stepped, that's a big deficiency. Putting that aside, tell me again, if you would, it seems to me that Twyman is a big hurdle for you. How do you distinguish Twyman?
Twyman, yes, Your Honor. The case, I believe the significant basis of the rationale in that case is by the quote that that the breach of duty had a substantial and direct causal link to her injury. She failed to do so since Twyman was the only witness to the accident, and she admitted that she did not know what had caused her fall. The jury could not reasonably have decided that she fell, for example, because she stepped on a slippery or uneven stair tread, and not simply because she missed a step or lost her balance while not holding the guardrail. She was carrying a bag of trash at the time.
Right, there's no testimony here that your client missed a step, right? And there's not even really testimony, I mean, you read it just to us just now. He feels a pain in his foot, but it's not even clear that the pain is linked to the stepping on to the platform. I mean, the pain could be just a cramping of his foot. Is there any testimony that he steps funny, that he rolls his ankle, that he steps onto something? I didn't see.
Well, there are two, we can't forget there are two concurring causes that we are alleging, right? The platform and the gap. Those concurrently, we believe, and we believe we've provided testimony to that effect that would allow a jury to infer that concurrently, because it's not the 7 inches that it ought to be, albeit not a staircase, because we're not talking about a step, we are talking about what the next step would be. So it's
No,
actually
I
a gap
understand-
case.
I understand that it could be the gap or the condition of the platform, but both of those assume that the pain is incurred after he makes contact with the platform. Either the pain is a result of the gap being too large, or the pain is the result of him stepping onto an uneven surface.
True.
But his testimony doesn't squarely support either of those theories. It's just, I stepped down, but there's no, I made contact and felt pain. It's just, I start to descend and I feel pain. And like I said, it could be just a simple cramp. Is there anything where he says, you know, it's not some internal bodily phenomenon here?
No, Your Honor, there is not a direct statement as
Or
to a
linkage
cause.
by him to contact with the outside world?
Well, you're right, he doesn't say, I mean, on the other side of the coin, he doesn't say my foot cramped and that's what caused me, right? So to establish, I mean, in the Zuckerberg case, which I believe is the more appropriate case that is applicable in our situation, to establish proximate cause, the plaintiff must present evidence from which a reasonable jury could find that there was a direct and substantial causal relationship between the defendant's breach of the standard of care and the plaintiff's injuries, and that the injuries were foreseeable. Most importantly, furthermore, a plaintiff may meet his burden by offering either direct or circumstantial evidence, and clearly this is a circumstantial evidence case. We do not have a direct, specific, I did this and this is what caused it. It is by the circumstances of the gap. And Mr. Maddox, I don't want to forget to mention that Mr. Maddox, regardless of the photo that's in the record or not, described the condition. He observed the condition. He said it was asphalt and concrete and sort of bumpy.
The condition of what?
Of the platform,
What part of the platform?
where he observed where Mr. Mallory was and had fallen.
At the time he came, well, at the time, where Mr. Mallory was at the time he came across Mr. Mallory, which may or may not have been the exact place perpendicular to the part of the platform that would have been directly at issue.
Point in being, however, the entire platform, this entire low platform is in that condition. You can see that very, very well by the pictures themselves. That of whatever pictures you have, the platform itself is not just one little spot in front of the door in which he was descending the train. The pictures show a platform that is in complete disrepair in a significant portion of the platform. And he describes that condition in his testimony.
Has the train moved yet when Mr. Maddox came and saw it? So did
No, Your
Mr.
Honor.
Maddox locate the part of the platform he saw and was describing with reference to the door of the train?
Yes, again, you combine the testimony of where Mr. Mallory was, which in terms of what he did, and that at some point it was 2 to 3 feet in whatever direction is not clear, but it is all in the proximity of the door from which, and the steps that he was descending. I mean, it doesn't go outside as if he was moved, away from the scene or considerably
Was there
away.
any testimony as to how far from the location where he fell Mr. Mallory was moved?
The only testimony I recall is that 2 to 3 feet.
I beg your pardon.
The only testimony that I recall as to movement is 2 to 3 feet. But it's all in the proximity, and what Mr. Maddox testifies to is that he is observing the area where the,
So getting back to Twyman, how do you distinguish Twyman?
because the testimony in Twyman that I believe is critical to that decision is that she could not rule out, and there's very specific, the court indicating that she had bags in her hand, and that she can't say she just didn't trip and not hold on to the handrail because she had bags in her hand. In this, there's absolutely no, talk about speculation in terms of other causes without any evidence whatsoever or any foundational information
Mr.
whatsoever.
Mallory was carrying things too, right?
I'm sorry?
Mr. Mallory was carrying.
He was carrying things, but he was holding on to the handrail.
But
It didn't prevent him
And-
from
and
holding
he-
on to the handrail.
And he also said that he couldn't say he didn't trip, right?
I'm sorry, that he couldn't,
Didn't, I mean, I'm trying to see if there's a real distinction to be drawn between Twyman in this case or not.
well, first of all, Twyman is a step case, right? Something happened on step 3 or 4, and that's the testimony, right? So it's a step case.
Was it clear, by the way, that whatever step she fell on was the step that was actually damaged?
It's not clear, it was either or, 3 or 4. I believe the expert in that case, as I recall, testified that they were uneven,
Both of them.
both of them.
So far it sounds sort of like Twyman is like this case. Now, I mean, so in other words, in Twyman, Ms. Twyman, is that right?
Although the expert wasn't allowed to testify, actually, I should point that out, because,
But in Twyman, the plaintiff steps on a defective step and falls, but cannot say what caused her to fall,
but can't rule out other,
and cannot rule out other.
whereas I suggest the testimony.
You think that Mr. Mallory did rule out other explanations?
Correct, because when he
Simply
indicated,
by saying he did not know what caused him to fall, you think that ruled it out, or how do you think he ruled out other explanations?
no, in his description as to what his actions were, he clearly indicated that he was descending the steps, that he looked at each step as he descended, he was holding on to the handrail, that the next step was the one where he would have to overcome the gap and step on the platform. And that's when he put his foot on the platform, felt pain, and went down.
And did his testimony rule out the possibility that the reason he felt pain in his foot is because as he was putting it down, he lost his balance because his backpack shifted?
Well, only to the extent that he says that he considered it a safe disembarkment. And again, that goes to credibility, but that's what he says. And when
Well,
asked.
again, obviously it became unsafe at some point because he fell and was badly injured. So the issue is just at what point it became unsafe. And he doesn't really know at what point it became unsafe.
Right, well, the conditions, obviously, the evidence would be as to the gap and the condition of the platform as the inference that could be drawn by evidence of that, as opposed to the lack of evidence of anything else.
Well, I'm just sort of struggling. I mean, here we are, and you're the plaintiff. And I'm trying to figure out sort of how much do you have to exclude to put forward a case that can then survive summary judgment? I mean, I guess I get that summary judgment shouldn't be granted when there's a dispute of fact, but it seems like the plaintiff has to at least knock out some possibilities in the universe, right? And so putting in your client's deposition, no, it wasn't anything that I was carrying that shifted. It wasn't the fact that I'm, borderline type 2 diabetic and on medication. It wasn't, I wasn't feeling faint. I wasn't, I felt fine. I had control of all my possessions, and I was making my normal safe exit holding the rail. Then maybe you could say, okay, well, what else could it be, right? But if he's saying, I have no idea what happened, and he's not speaking to his physical condition, he's not speaking to the things that he is carrying, then why is it that you've actually presented enough to survive summary judgment?
Well, at this stage of summary judgment, the facts being taken in the light most favorable to the non-moving party, with the evidence that has been presented as to a substantial factor in what caused the fall, that we have met the burden at this stage to show the duty breach and the causation of what occurred.
But I'm talking about an absence of facts, and that seems to be what Twyman supports, is you at least have to put forward something.
Well, but there were, the point that I'm making, at least as to Twyman, is that there were facts that the court considered in the record as to why something else could have happened. Our record is devoid of that. And in terms of a burden of...
Well, is it devoid? I mean, he was carrying a lot of stuff. He was borderline type 2 diabetic. He was on medication.
Where did borderline...
That's on the transcript at 264.
Oh, well, interestingly, there is no, speaking of causation, there is no evidence of those facts. Certainly the trial court didn't address it, but I understand it's de novo. But as to the absence, proving a negative is an interesting concept in terms of the plaintiff having to affirmatively prove duty, breach, and causation.
It's actually proving a positive. You have to prove what caused.
Right, yeah, to always, my way of thinking, it's a positive that you have to prove that there is a duty that was breached that caused. And in this instance, we've put, first of all, it's a totality of the circumstances. It's in the taking, there would have to be no facts whatsoever that a jury could glean to find a breach that caused this injury in order not to survive summary judgment. In court, maybe we don't, if we don't have any more in court, there's a directed verdict, or it goes to the jury and they don't find for us. But at this stage, the jury would have to find no evidence whatsoever. Or the court would have to find, in its opinion, or you all would have to find that there were no facts that could be gleaned whatsoever at this stage in taking the facts in the light most favorable to us.
I don't
that
think
we
the
could
standard is
prove.
quite, no facts can be gleaned in support of the claim. It's, you know.
Material.
Well, and that would permit a reasonable juror to find by a
Sure.
preponderance whatever element of the claim is at issue.
True. No, absolutely. I mean, all the elements are there and that it would be a reasonable inference, absolutely. We suggest that there are sufficient facts that survive summary judgment in this case. Thank you.
Counsel, thank you. Take the case under advisement.
All right.
This court is now adjourned.